But I think in the normal course, a complainant went to the CCRB, or a complainant's complaint was referred to the CCRB. They're in communication with the CCRB. The CCRB, again, in the charges and specifications cases, they are the prosecutors pursuant to the MOU. So both because of the pre-existing relationship and because of their role as the prosecutors in the case, I think it actually does make sense that the CCRB would be the ones sort of in communication with them.
How does the NYPD account for adjudicating allegations of misconduct by individuals who themselves play a role in reviewing disciplinary cases? For example, allegations of misconduct by the chief of the department.
So the chief of the department does not review disciplinary matters. The chain of command on this is very clear. The department advocate reports to the first deputy commissioner, who reports to the police commissioner. The chief of IAB reports directly to the police commissioner. I report directly to the police commissioner. The operational chain of command, department or otherwise, is not in the chain of command when it comes to disciplinary matters.
Well, no, I mean the question is in regards to, I guess, the process, not necessarily the process of the chain of command, but the process of reviewing those allegations that
Right.
are in reference to, say, for instance, the chief of the department. And in cases like that, like what is the how do they account for that allegation?
Sure. So obviously, when you have an allegation against a high-ranking member of the department, that is, of course, significant and sensitive. But I think the whole point is, right, the police commissioner has plenary authority over discipline. She is responsible for discipline in the department. She is the decider in every case, whatever the person's rank, whether it's a police officer who just started or it's the chief of department. The police commissioner is responsible as per the charter. She's responsible for the good order of the department, for discipline in the department. And ultimately, when it comes to disciplinary matters, she is the decider.
To what extent is the mayor of labor officials consulted on individual disciplinary decisions?
I'm sorry, Chair, I didn't hear the question. If you could just repeat that, please. I didn't hear the question, I'm sorry.
Oh, to what extent is the mayor of labor officials consulted on individual disciplinary decisions?
I'm not familiar with that occurring at all. I can't, that our process does not account for consulting with, I'm not sure what you mean by labor officials. You mean the unions? The unions will certainly communicate writ large with the department on matters of concern to the unions. If there are things they think are unfair at a general level, that's the unions, doing frankly what they're supposed to do, which is advocating for their members in terms of policies and practices. But in terms of speaking about individual cases, no, that should not be happening.
Any mayoral involvement?
Certainly not to my knowledge.
Or consultation? No. Okay. Almost exactly 1 year ago today, the Yates report was published as part of the ongoing stop and frisk litigation. This comprehensive report included 51 recommendations to improve NYPD's disciplinary system. Can you let us know what, if any, of these recommendations have been implemented by the department? Sure.
So there is to answer your question, there is an ongoing process with the monitor where there's essentially, with it, we work with the monitor all the time on a variety of matters. There is a working group, member of the monitor's team, and members of the department, and members of the plaintiff's team in the stop, question, and frisk monitorship, actually going through those recommendations, discussions, consensus, where there's disagreement, working to find common ground. So that process has been ongoing, and that was at the direction of the monitor. That is what you want us to do, and that is what we are doing. And ultimately, that working group will complete its work, and then, from that working group. But that's ongoing.
I'm going to open up to the other committee members, starting with the public advocate, Jumani Williams, for your questions. Oh, I'll come back? Okay, I'll come back. So we will start with Councilmember Caban.
Thank you. Is this one yours? I think it's, okay, great. Well, there's one over here too. Getting used to the new room and tech. Thank you, Chair. I'm going to start with what the public advocate mentioned in his remarks. In 2019, Lieutenant Jonathan Rivera violated NYPD department guidelines when he killed Alan Feliz at a traffic stop. So just for the background, for the record, the NYPD's own Deputy Commissioner of Trials recommended firing the lieutenant following a disciplinary trial initiated by the CCRB, which obviously is in line with the NYPD's disciplinary matrix. I think it's also worth mentioning that NYPD trial judge had made this finding and recommended the firing of an officer, and in the decision stated that they found that the circumstances, the evidence supported a finding of guilt to assault in the first degree, which is a Class B violent felony. Basically, it requires that there be intent to cause physical injury and that does so with a deadly weapon. And to be clear, if somebody were charged and found guilty of that in our criminal courts, they would be facing mandatory upstate prison time. So with the novelty of that finding, very, very rare, and the serious charges and that were substantiated, my question is this: why should the police commissioner's judgment be substituted for the deputy commissioner of trials, who's the fact finder in an NYPD trial room?
Okay. Right. So I guess there are a few different aspects of that. As you know, as per the charter, right, the police commissioner is the final arbiter of discipline. And the way the framework works, right, and this is not unique to the police department in terms of how you have a fact finder who conducts a trial, who hears evidence, who takes testimony, writes an opinion, and then the same way that in the criminal justice system you have appellate courts or appellate review. Obviously, it's not identical to the PD system, of course, as you know, but the idea is you have a fact
in
finder.
An appellate review, by the way, in the criminal courts, that person would be in upstate prison awaiting the outcome of their appeal, not only not still on the force, but given a promotion and continue to police in our streets.
So, look,
my question is really simple. Like, why should the police commissioner's judgment, this police commissioner's judgment, be substituted for the deputy commissioner of trials, who is the fact finder in the NYPD trial room?
Again,
Why?
If you're asking why in sort of a system generally, it is not uncommon to have a fact finder who makes findings and recommendations, and to have someone else who is ultimately reviewing that.
But it is
making a final
historically
determination.
uncommon for an NYPD trial judge to find an officer guilty of a Class B violent felony and say that that person should be fired. It had only happened once before in the history of this process. And so given how serious that is, given how the novelty of that, given the threshold that has to be met, why should the commissioner be able to ignore that?
She did not ignore that. What the police commissioner did, as she is required to do, under the charter, as the person responsible for discipline, the police commissioner looked at, hold on, I'm answering your question. The police commissioner looked at the facts, and I hope you've had an opportunity to read the police commissioner's decision, because I understand you think she got it wrong. I get that. But anybody who reads the police commissioner's decision will come away, I think, with the inescapable conclusion that she looked very carefully at the facts, carefully analyzed the trial record, looked at the testimony of witnesses, the documents in the record.
Heard. So let me follow up with this question.
Carefully looked at Commissioner
She looked at things
Maldonado's
carefully
opinion,
and did something different. I only have a little bit of time left, and you're taking up the time on the record.
Please give Councilmember Caban some additional time. I would like the opportunity to answer her question, and then you could have additional time, please, to ask me questions. I do want to give her a full answer.
Sure.
Okay. Anybody who reads the police commissioner's decision, whether you agree with it or you disagree with it, I think anyone who reads that will fairly come away with the conclusion that the police commissioner thought long and hard about this case, looked very carefully at the facts and at the law, carefully reviewed the entire trial record, which included, the AG's determination as well, but looked incredibly carefully at the trial record, considered in a very granular way Commissioner Maldonado's analysis, pointed out places where she agreed with Commissioner Maldonado, pointed out places where she disagreed, and ultimately, the police commissioner did what she is required to do, which is look at the facts, apply the law to those facts, and then ultimately make the decision that she thought was correct on the facts and on the law. That is what she was obligated to do, and that is what she did.
Thank you. So to provide more context on that, you made the analogy around the appellate courts. I will say that by rule, the appellate courts give deference to the fact finder in a way that the commissioner did not give any deference to the fact finder. In fact, Commissioner Tisch dismissed the findings point by point. The actual language of the letter substituted her own credibility assessment for the DCR. So I don't think that flies, but I'm going to move on. I want to sign up for a second round, but I want to at least end with this, right? Again, we found that the commissioner decided to overrule not just her own deputy commissioner of trials, but also the CCRB. So my question also is should the police commissioner have unfettered discretion to overrule and reverse findings from two independent oversight agencies? And again, in a situation where we're talking about assault in the second degree, anybody else found guilty of that would have to be serving upstate prison time. And what we're asking for is for this officer who right before this incident had shot a 15-year-old and had over 40 other complaints to not be on the force to be that kind of danger to our community. In the testimony, it says, whatever disagreements there are about particular disciplinary cases, we are committed to a disciplinary system in which cases are carefully reviewed and resolved through a fair and thorough process. Throwing away the rulings and findings of two independent oversight entities in a case where this has never really been found before because the threshold is so high in protecting people with a badge when they inflict violence. That does not sound like, if that reflects the core values underlining your disciplinary system or this commissioner's disciplinary system, as is stated in your testimony, that's a problem.
Councilmember,
Thank you, Chair.
If I may just to respond to one point very quickly. Again, if you read the police commissioner's opinion, she did not just throw away the findings by Commissioner Maldonado. She looked at them incredibly closely, incredibly carefully, said where she agreed, said where she disagreed. Where she disagreed, she explained why.
Thank you. We'll come back for a second round for sure. I'm now going to pass it to the public advocate.
Thank you so much, Mr. Chair. I'm going to probably stay a little bit on this, but I first want to just put context because sometimes the public does not understand the nuances of things that I've said. And so what the police department also often says when we're pushing on these issues is that there's tremendous amount of oversight on NYPD, and they'll mention CCRB, they'll mention IAB, they'll mention other things, they'll mention decrees. What the public may not understand that most of that often doesn't matter because the one person that can make the decision is the police commissioner. And I say that so hopefully if someone is hearing this, when they hear all these things about all the oversight, the main problem is one person can override all of it. So it's almost as if we don't even need a deputy commissioner as a judge. We don't need CCRB, we don't need anybody. All we need is a commissioner. That is the problem. And the way you mischaracterized what the commissioner did, I think, is inaccurate. I think what the commissioner did was decide to agree with the Attorney General's decision. And the Attorney General had no trial. The Attorney General also had a higher threshold of which to make a decision. The judge, administrative judge, actually conducted a trial and had much more facts than the AG ever did. We had a judge that actually said she believes this police officer lied on the stand. So she said that this person did not follow departmental policy, lied on the stand, as mentioned, had a history before this case, and we have a commission that still decided to override two independent areas, one of them which is in her own department. that is a problem when we have to go back to our communities and say, trust the process. Because no matter what you say, the process absolutely did not work in this case. And we have someone who killed someone, who lied on the stand, who was found guilty of violating departmental policies, and is still on the force, except at a higher level, making more money. That sends a horrible, chilling feeling to a community. That even when you have a case where the departmental judge never agrees, where everything lines up, you have a commissioner that's still overruled. My first question is, you mentioned in the testimony the amount of times that the NYPD is now matching CCRB. I just want to make sure you said that in the first half of 2025, it was 91%. Is that correct?
Yes, and I just want to emphasize that in doing this, as I said in the testimony, we're relying on the CCRB's data, right? This is not just the NYPD saying we agree. The CCRB regularly publishes its concurrence rate, and if you look at their reports, they really show how they get there, and there's a lot of analysis. So if you take the CCRB's data, excluding the short SOL cases from the beginning of the year, and I think that is fair because we have stopped doing that. So yes, based on the CCRB's data, if you take out the short SOL cases, we're talking about a concurrence rate in the first half of 2025 of 91%.
Is there a breakdown in the type of charges, lower level, high level charges, where the percentages
Yes,
may be different?
I have that. So I'm going to do it just sort of apples to apples. Again, I'm taking CCRB's data, and I'm excluding the short SOL cases. So the concurrence rate, the overall concurrence rate is 91%. The concurrence rate for the non-APU cases, that's the cases that are not charges and specifications, is actually 95%. And the concurrence rate for the charges and specifications cases is 71%.
7%. Okay, and what's happened with explain what's happening with short SOL cases?
So the short SOL cases, the police commissioner reversed that policy.
Yeah.
There is no longer any sort of short SOL rule or policy. There have been, and that occurred on March 1. So since March 1, there have been 3 cases that came in right before the SOL was about to run. The department advocate, for various circumstances involving those particular cases, the timing, the circumstances, the nature, a variety of things, those 3 cases were administratively closed, not because of some rule, but because of analysis and work that the department advocate did. So the short SOL rule, policy, practice no longer exists.
Okay, I'm going to ask these 2 questions, and you can just answer them. I'm going to look into these numbers, so I appreciate it, and have my team just kind of dig in. I did want to just have a better understanding of when the department, how you make decisions of when you're going to deviate from CCRB. What are those reasonings? And this has to do with in custody deaths, which are increasing, which are very much troubling. But how are officers, especially trained ones, determining medical urgency? Because obviously it's not working while folks are in custody and they're dying. So just want to understand those 2. And I'll just end with a commentary. One of my most disappointing moments with Commissioner Tisch was the Alan Felice case. It was very disheartening. She made a terrible decision. And then shortly after decided to fire 31 officers who were hired through no fault of their own because of decisions that the police department made, even though those officers had no known cases of doing anything wrong. And a lot of them happened to be black and brown. So I'm looking very much forward to what she's going to do in the Wynn Rosario case. Hopefully it's the right thing. I don't think it'll bring any sense of justice to the Alan Felice case, though. If you can answer those 2 questions.
Sure. Well, I should say, in terms of the department policies and when prisoners have medical needs, we do have very significant and important policies in that regard. Neither Commissioner Rahman or myself are really the right people to answer that question. So what I'd like to do is we'll send a letter sort of to you, to your office, sort of walking through some of those policies to answer your question. And then in terms of the police commissioner's decision to depart from the CCRB, it is very much case by case. The goal here is to look at the facts, to look at the relevant policies, And as I said earlier, there are moments when the police commissioner agrees that there was misconduct, but disagrees about precisely what the penalty should be. There are other times, rare, but it does happen, when the police commissioner believes that there was no misconduct. I will say, one thing that does structure this for us and the CCRB is the discipline matrix. So the CCRB can make a recommendation outside the matrix. That is incredibly rare. On a finding of misconduct, the department can deviate from the matrix. That is also incredibly rare. Anytime the department finds misconduct and then imposes a penalty that deviates from the matrix, when the police commissioner does so, there's a letter that we write, that we post on the department website. I think it's happened once this year. It is incredibly rare.
Thank you. Mr. Chair, can I ask one additional question? Thank you. I just wanted to get on the record. Is my assessment correct that the commissioner chose to align with the decision more of the Attorney General than of the department judge?
And I appreciate the question. So I think there are two different things happening here, and I'd like to address it. The Attorney General, as you said, of course, in deciding whether or not to bring a criminal case, 100% higher burden of proof. Higher burden of proof, significantly higher burden than in an administrative proceeding. The Attorney General wrote a report. In that report, I think it's actually very clear that the Attorney General, the report goes well beyond the question of just proof beyond a reasonable doubt, and says, that report does say that in the report's estimation, Lieutenant Rivera reasonably believed that he had to use deadly force in order to save the life of a fellow officer. The report does say that.
I was going to say, it's a long way to say yes. My assessment.
I'm sorry, I'm not finished,
Okay.
if I may. So she did reach the same conclusion as the Attorney General. That is true, right? The Attorney General reached a conclusion applying the law to the facts, and the police commissioner did reach the same conclusion. They are in agreement. But again, I think anybody who reads the opinion will see that the commissioner relied on the record before her, right? She's relying on the record before her, citing the record before her, documents and testimony, and the entire opinion essentially is engaging with the facts and the law and Commissioner Maldonado's analysis and explaining where she agreed, where she disagreed, and when there were points of disagreement, the police commissioner explained why. So, did she agree with the Attorney General in terms of the conclusion? Yes. To the extent you are suggesting that she simply adopted the Attorney General's view, I don't think that's the case at all.
I believe it was. Thank you, Mr. Chair.
Thank you. We're going to go now to Councilmember De La Rosa.
Thank you, Chair. And I want to thank the public advocate and my colleagues for uplifting Alan. Alan was actually my constituent. So I have the responsibility of going back to my community and explaining to people how we're supposed to build these relationships, especially in the face when the NYPD is launching units like the quality of life units that are disproportionately targeting community of colors like the one I represent in Washington Heights. How do I go back and say to my constituents, trust them, they're gonna do the right thing? When one of ours was killed on the streets of New York City, a trial judge found the officer guilty and the police commissioner basically said no punishment. I want to also emphasize about the Attorney General's report that the Attorney General's report has a higher burden and also talks to criminality. The Commissioner of Trials and the police commissioner could have suggested misconduct was present and a punishment for that misconduct. Instead, Jonathan Rivera is still patrolling our streets, can still patrol our streets, and has been promoted to lieutenant. That flaunts trust in our community. That fails our communities in terms of building trust. And so my question to you is, what is the message to New Yorkers like the Feliz family who's watching us right now when they say we cannot trust the NYPD for these reasons? What is the message that we are sending to New Yorkers at this time?
I understand that you think the police commissioner got it completely wrong. I get that. Obviously, in terms of the Felice, the loss that the Felice family has experienced, I have no words for their loss. I wouldn't presume to try. The police commissioner has a duty to analyze the facts and apply a lot of those facts as fairly and as thoroughly as she can. That is what she did. And I understand, again, that you and others, there are people who strongly disagree with her. I get it, and of course, I respect that. But in terms of the process, in terms of how the police commissioner went about doing this, she was doing her job, what she is obligated to do under the charter, and she applied the law to the facts and reached the conclusion that she believed was the correct conclusion on the law and the facts before her.
The message to New Yorkers is that there is no accountability and that the police cannot police themselves and that we cannot rely on Commissioner Tisch to police her police. That was the test for Commissioner Tisch, and she unfortunately failed. And I was one of those people that actually thought that she would root out corruption. But we have the opportunity to bring justice to other families, and there have been delays, like Win Rosario, who hasn't had a trial set yet, like Darrell Smalls, who also is waiting for accountability, like communities like a young woman who just died in police custody in the Bronx, in the 41st precinct, Sanaya Cheatham. What is the message that this police commissioner and this administration is going to send to those families that are still awaiting a semblance of justice? What is the process? What is the delays? And what have been the obstacles that have led to information sharing not getting to the families? In the specific case of the 41st precinct with Sanaya, as the investigations happen, and we understand that investigations must happen when there is an in-custody death, why isn't there more information that is given to the family as investigations are happening? What we continue to hear from the Cheatham family is that they have not been given proper information, that they have been left in the dark. And as you could imagine, for a family that is grieving their child, that is something that causes desperation, but it also adds to the grief that these families are facing.
So I can't speak to the particulars of this case. What I can say, though, is that there is often, when there's ongoing investigations, there really is a tension and a balance that needs to be struck. On the one hand, with the interest that you're talking about, which is keeping a family informed, keeping them up to date. To the extent you have an ongoing investigation, right? You have to balance, right? You don't want to get out ahead of things. You don't want to give inaccurate information. To the extent you're exploring this or that, you don't want to compromise anything involving the investigation. So I think, and that attention exists in so many cases. And I think the department tries to strike the appropriate balance. But I agree. There's a real tension there between the transparency that a victim or a victim's family is looking for, on the one hand, and on the other hand, the needs of investigators to figure out what transpired. And again, I do want to come back to something I said earlier. I appreciate there's very strong disagreement about certain disciplinary decisions, anger about those decisions. But in terms of what the message would be to New Yorkers, the message, I think, from Commissioner Tisch is we are committed she is committed to doing this to the best of her ability, the department doing it to the best of its ability, to have a fair and thorough process. We are committed to that. We do believe in that. That is what we are trying to do.
I appreciate your comments, and I think that all of us want safe communities. We all want to be able to walk down the street, but that shouldn't be a right that's afforded to just some. As a mother on this dais, I know I'm not the only one. When our children leave our homes, we want to make sure that they can come back home. And this is part of that conversation, especially in Black and brown communities. So I would ask you to take a look at your procedures, to take the questions of my colleagues seriously, and to make the appropriate changes in order to get these families the answers that they deserve, because no one will bring their children back. But we can do better for the next generation of New Yorkers that is growing up here.
Thank you. I think we're. This is a heavy moment, and the heaviness of it is, as a father of 10, I'm also in alignment with what is being said and what is desired and requested of the police department. And what we want, of course, is to make sure that we do have a police department that is, as it's said, the best department in the world, the finest, that offers courtesy, professionalism, and respect, as was on the, I would say, the older model cars. It's still on some of the newer ones. But we definitely have an opportunity, I think, to really align with the moment of being able to put the supports around the community to be able to protect and serve them in a really powerful way. I'm going to move to Councilmember Stevens.
Good morning.
Good morning.
I've said this so many times in these hearings, and I'm going to just say it again. We have to address the trauma and in the communities that NYPD has created. And it's these moments that we talk about. So when I say the trauma, this is a trauma, again, that is being caused in the Black and brown communities that we say we don't trust you, that we say we don't feel safe. This is the moment. Every time we come, we hear the same thing. And so even saying, like, what's the message to New Yorkers? The message is that NYPD is above the law. That's the message. It's not that the commissioner took all the things into consideration. It is that NYPD is above the law. And this is why we don't trust you when we're in the communities. And it's a rip. And what this does is it makes us not safe. It makes us say, I'm not calling you in the moment when I need you the most. So this is the moment. So please take that back to the commissioner, that this is why for years we say we don't trust you. Because when we are shot dead like dogs in the street, you say we took everything into consideration. That's why. I have a couple of questions. The first question is, on July 5th, 2025, Sanaya, an 18-year-old from the Bronx, died while in the custody of NYPD Police Department. As for you testifying, we must rely on the commissioner to make investigation a priority. Can you tell me as of today if the investigation has become a priority and whether any officer has been disciplined?
So I'm not familiar with the particulars of that investigation, and quite frankly, to the extent we're looking at any of these matters, it would not be appropriate for me to speak about this here. What I will say, though, is that DOI is looking at deaths in custody in the department generally. They're going to look into this. My understanding is they're going to do a report, and that is underway.
I will follow with you offline because I definitely would like more details around where we are and what that looks like and what the outcomes we should be expecting. When DAO is reviewing CCRB cases, are they merely reviewing it for consistency, or is it a reinvestigation? And to what extent does CCRB have an opportunity to rebuke any decisions to divert in a downward departure from recommendations for discipline? So are they able to review any of these things?
Yeah. So you want to take the first?
Sure. As far as what DAO does, we do not conduct a fresh investigation. In other words, we do not gather additional evidence. There's no effort to re-interview anybody, anything like that. We simply take the information that's provided from CCRB and review it and evaluate it and then make a recommendation to the police commissioner.
And then as to your second question, certainly in the charge and specifications world, right, whether it's pursuant to P2 of paragraph 2, provision 2, of the 2012 MOU, or provision 6, cases where the police commissioner is considering departing from CCRB's recommendation, yes, there'll be a letter to the CCRB. They will then write a letter back, typically, right? There's a whole back and forth. And that correspondence actually is public. It's on the CCRB website. In every one of those cases, CCRB will post it. I think typically they post it quarterly.
Yeah, it's so interesting. When I was in Oakland and they were talking about the CCRB, where the commissioner and the chair of CCRB, they're seen as the same. And so they have to come to a decision together. And it sounds like that's where we need to be moving, because having letters going back and forth doesn't seem very, very productive, especially when one can trump the other. And so it seems like we need to be moving in a direction where CCRB actually has power to not make recommendations, but also be seen as an authority in the room, because that seems counterproductive to me. What would improve retention? So I know, especially with like the investigators for CCRB, there's not a lot of retention rates. So could you talk to me about like what are you guys doing pertaining to retention rates and keeping your investigations at CCRB, investigators at CCRB, and what does that look like, the attrition?
So I think that's really a question for CCRB. Those are CCRB employees. They're not department employees. We do have a CCRB liaison unit, a full-time unit. What they do is they deal with the CCRB, and a few of them actually do sit over at the CCRB office.
How many people are in that unit?
It is, I believe it's around 18. 18 members in that unit, and we have a team of.
And are those officers or are those administrative positions?
On the department side, it's a mix.
On the department side.
Yeah. So our CCRB liaison unit is a mix of uniform and civilians. We have
how many are uniform and how many civilians? I'm wrapping up right now, Chair.
I don't have the breakdown here, but I certainly can get it for you.
Send that over, please.
Yeah, sure. We have a few members of our CCRB liaison unit who actually sit with the CCRB, which really does facilitate getting them materials. But then in terms of the CCRB investigators, those are CCRB employees. And in terms of...
Yeah, but on your side, could you talk about the liaisons on your side? So
yeah, sure. I mean, I don't think we've had a retention issue there. And I think the relationship actually, I think is very, very good. My hope is that CCRB will see the same thing when they testify. It's an incredibly productive relationship. When there are any points of disagreement or issues in terms of getting documents, what they need, timing, I think we have a great system in place where there's communication. If there's disagreement, it gets elevated. I got to tell you, I cannot remember the last time when there was some document request or video request or something of that sort that we were not able to sort out. It's actually a very, very productive relationship.
And could you give me the breakdown of how many actual officers and civilians are in the department? I would love to know what that breakdown looks like.
We will get that for you, sure.
Thank you. We'll now hear from Councilmember Holden. Councilmember Joseph, sorry about that.
Thank you, Chair. I just have a few questions. What is the current disciplinary matrix used by the NYPD, and when was the last time it was updated?
It was last updated in September of 24.
2024?
Correct.
And what new things were added to that matrix?
I'm not sure actually from
Can
the
you share?
previous.
Or can you get back to the committee on that?
From
Thank
the
you.
previous iteration, what was updated in September of 24, we can get that for you.
Thank you. How many officers have been terminated on misconduct in the past 3 years, and what type of violations were those?
As far as, I can give you the numbers as far as terminations, you want to know?
Terminations, violations.
2023 terminations were in total 63, in 2024, 46, and thus far in 2025, it's 48. As far as what the specific breakdown of what the violations were, I'd have to get back to you on that.
Okay, Chair, we'll be waiting for this from them. What is the average time between a complaint and a final disciplinary action? How long does that take?
You're talking about CCRB or?
Yes, sir.
Well, generally speaking, CCRB at least will run very close to the 18 months of the statute of limitations before that matter is brought to us. So if it's a less than charges cases, meaning something that isn't handled by APU, you can figure that effectively the entire 18-month period is generally how long it takes. For an APU case, meaning if the charges and specs are recommended by CCRB, that's prosecuted by APU. So once we serve the charges on their behalf, those cases can run many, many months, if not years, before they're actually brought to trial.
What's the average year a case can take?
I'm sorry?
What's the average?
I don't have that for you, but
So you will get back to the committee on that.
Anecdotally, I can say that when I look at cases that come in for settlement negotiations, right, because not everything goes to trial, I have seen cases that were charged, incidents from 2022, 2023, that are now hitting my desk for plea negotiations. So it takes
About 3-year average.
I would say it's fair to say.
Councilmember, I just want to add one point on that. I think it's important. Sometimes those delays are not in our control, right? In other words, it just depends. It really does depend on the case, but sometimes.
What is in your control? If those are not, what's in your control?
No, so for example, obviously, when you've charge investigations have been served, right? So you have CCRB as the prosecutors. We don't control kind of how they think about timing and when they want to go to trial. You have the respondent and the respondent's counsel. We don't control them either when they want to go to trial. And again, there are various things that can go into that. Is one of the sides looking to get additional evidence? Do they want to talk to another person they're hoping to find? Do they want to have plea discussions, which can be done quickly, can take a long time. So both of those parties, in terms of what they want to do, in terms of going to trial and timing, we don't control. Now, once the parties are asking for a trial date, then we obviously definitely do control, or the trial judge controls when that trial date is set. And my sense of it, I don't have precise data for you, but my sense of it is once the parties want a trial, I think typically within 2 to 3 months they're getting a trial date.
Okay. How do you handle repeat offenders who accumulate multiple complaints or violations?
So the matrix accounts for this, and the way the matrix works is you have your presumptive penalty, you have a mitigated penalty, you have an aggravated penalty, and what goes into mitigation and aggravation. You can imagine a number of different types of things, but one of those things most definitely is the person's disciplinary history, and that makes sense. Obviously, it matters what kind of misconduct we're talking about. There's an incredibly wide range of misconduct, but it matters if someone has no disciplinary history versus someone has an extensive disciplinary history, and the matrix actually accounts for that.
I'm going to deviate a little bit. What are the procedures for running a CCRB investigation when a force investigation division isn't closed? Does all the material get shared, especially for example, in the Sanaya Cheatham case?
Right. So since the new MOU at the end of 2023, right, the way it'll work is an FID investigation. That's just ongoing, right? Materials will be provided within 90 days of request. I think we've been doing it in less than that. I think, again, I don't have precise data, but I think you'd find it around probably like 70 days typically. And the way the MOU works, and this is, by the way, it's available on the CCRB website, it's public. So all materials are provided. The fact there's an ongoing FID investigation does not prevent anything from being shared. What the MOU says is, to the extent you have, not FID, but if there is any criminal investigation ongoing, that could be by the Attorney General's office or a DA's office, whatever it may be, CCRB is to communicate with any criminal investigative entity before they go and talk to witnesses, right? So, and PD is not involved in that. In other words, if CCRB, they have the materials now, they want to go talk to a particular witness, there's some sort of ongoing criminal investigation, CCRB is supposed to go to the prosecuting or investigating entity and say, DA's office, AG's office, hey, we want to go talk to this witness. Will that be a problem for your case? And there's a dialogue between the prosecuting or the investigating agency and CCRB. NYPD does not play a role in that
When do you get involved in that?
No, we don't get involved.
You don't get involved at all.
No, that's by design. The whole point with the MOU is we provide the materials, and then in terms of witnesses, CCRB has to go and talk to, again, the AG's office or DA's office to figure out, what CCRB wants to do, consistent with not in any way interfering with a criminal investigation.
Earlier, you said DOI is looking at it and probably released a report. Did the commissioner request that, or you're not mandated to do that? Do you think that needs to be changed?
Do I think that what needs to be changed?
Earlier, when you talked about the change, looking at to release the report.
Sorry, to be clear, the DOI, my understanding is that DOI is going to do a report on deaths in department custody. I can't speak to the scope of their report or what they're going to look at precisely, but I know that DOI is going to be looking at that.
Thank you, Chair.
Thank you. We'll now hear from Councilmember Holden.
Thank you, Chair, and thank you, Deputy Commissioner. Nice to see you again. And I know the Police Commissioner for maybe eight, 9 years now or more, and I find her to be fair. I find her to be intelligent and hardworking. But what does the police commissioner generally bring to the table in these discussions of investigations? Let's say a trial judge might disagree. What insight would a police commissioner have that you feel that the decision could be overturned? Let's say, or the recommendation from the CCRB shouldn't be followed.
Right.
Like what talents?
Yeah, sure. So, and I'm not sure if you mean Commissioner Tisch in particular or the police commissioner.
It doesn't
generally.
have to be the current commissioner. I'm just saying generally.
Yeah. So the police commissioner, and I think this is the idea, is what underlies the charter, and frankly, the New York Court of Appeals has talked about this repeatedly as a very strong New York State interest in having a person who is ultimately responsible for the police department, being the one who's ultimately responsible for discipline. Right, the police commissioner, particularly, we have a very strong chain of command, as you know, and the police commissioner is the person who is responsible for giving the orders, for setting policy, for setting procedure, for the good order of the department, and ultimately, the police commissioner is the person who is responsible to the public, in terms of the functioning of the department. In all respects, that's true in terms of fighting crime. That's true in terms of policing misconduct and imposing discipline. And I think it makes a lot of sense, particularly in a police department, to make sure the
Is it true generally that officers that are in more high-pressure situations, they have more intense jobs, let's say, within the NYPD. They're in communities that have higher crime. They're investigating many more cases. Do they generally have more CCRB complaints than officers that are obviously not in a high-pressure area or precinct?
Well, I think everything else being the same, if officers are engaged in more enforcement action, everything else being the same, they're more likely to get CCRBs.
They're more active.
Yeah, and to be clear, I mean, I don't want to paint with too broad a brush. You can have officers who are very active who don't have a lot of CCRBs, but just in the nature of things, because CCRBs are by definition about civilian complaints, and if you think about the categories that fall within CCRB's jurisdiction, yes, if an officer is making more arrests, if an officer is more active, everything else being the same, yes, it is more likely that officer will get CCRB
they've
complaints.
made a number of arrests, maybe more than some other individuals in the police department. I know some have made hundreds and hundreds of arrests, and so they're put in a position in harm's way many more times. But split-second decisions also, we're human, and there are cases where you can't second guess. You have to make a decision in a split second. But let me just talk about, there was some criticism of how the NYPD communicates with victims' families. What's appropriate and what's not appropriate? What can you do in the NYPD to communicate with a victim of a police shooting, let's say the family of a police victim? What can you do during let's say, a trial?
Right. So I think a very important distinction is a case open, is a case closed. That's a crucial distinction. I think once a case is closed, whatever the posture, right? in a criminal case, right? Our detectives investigate some crime, right? And they're talking to there's a victim or a victim's family, or it may be. Obviously, we have a lot more latitude once a case is closed. When a case is ongoing, I think, as I said before, there's a real tension or a balance that has to be struck. Obviously, you don't want to keep a victim in the dark. You don't want a victim's family to be in the dark. Nobody wants that. You also be very careful about first of all, not compromising an ongoing investigation. That would be a terrible thing. You also want to make sure you're giving accurate information. And in the nature of investigations, things can change over time. If you have a suspect, you think that person committed a crime, then you realize, okay, they didn't do it. It was someone else. The last thing you want to do is be giving a victim inaccurate information. They have to come back to them and say, "Oh yeah, sorry, never mind. We told you this, but now we realize something else." Right. No one wants that.
Right. Thank you, Chair.
We'll now hear from Councilmember Ariola.
Thank you, Chair. Thank you, Commissioner, for always keeping your cool and giving good, solid facts. Thank you both. So in reading your testimony, it shows that there have been many changes during Commissioner Tisch's administration as commissioner. And I want to thank you for that, because it takes a person of courage to admit that previous policies were perhaps not correct and make those changes. And it's not easy when you're deciding on someone's fate, especially when, as Councilmember Holden mentions, it's often a chaotic scene when these officers are going in. And I'd just like to say, with the Wynn Rosario case, the commissioner saw fit to bring disciplinary action for excessive force for Officers Alongi and Cianfrocco. So there is times when the commissioner feels that she is within her rights, no matter what whether it's the AG or anyone else does and reports. The investigation is still ongoing with the AG, but she's seen fit for that. That being said, what I'd like to address really is the Q teams. It was mentioned earlier that there was an issue with, maybe fear of the Q teams. Now, the Q teams went out to every council member, or they should have, because they were instructed to do so, and explained what their role was. And their role, as far as I am concerned, is to diffuse and address quality of life issues before they accelerate into something like we've had with many of the issues that we spoke about today in the cases. Perhaps you could just redefine for us the Q teams and their mission, what their duties are.
Sure. And I should say at the outset, neither I nor Commissioner Rahman are really the experts on the Q teams, but I can say that the Q teams at bottom, at core, about responding to 311 complaints. I mean, that is the heart of what the Q teams are supposed to do. And that's how I think to think about success for the Q teams. That is, are they responding to 311 complaints? Are they resolving those complaints in a timely fashion? Now, of course, can there be circumstances when you respond to a 311 complaint and that escalates into something else? That can happen, yes. So I'm not going to say, the Q teams never end up getting involved in responding to a more significant criminal matter or taking enforcement action. I'm not suggesting that. But at bottom, sort of the Q team's purpose and goal and how to think about success is responding to 311 complaints.
Right, and that is their core
mission.
Core mission is
Yes.
to do that. Thank you very much.
Sure.
Thank you. What criteria does the department use when determining whether extraordinary circumstances justify deviating from the presumptive penalties outlined in the disciplinary matrix?
That's actually a hard question to answer because it's so fantastically rare. Again, I think it's like once this year that happened. I'll answer it, I guess, more conceptually. The matrix accounts for various things. I would think if you had a situation, and this would be a rare situation, in which the matrix, there was some unusual fact pattern, very unusual fact pattern, unaccounted for by the matrix, right? The matrix is thinking about, again, someone's disciplinary history, aggravating and mitigating circumstances, but it's the nature of, nature of things, sometimes certain things are just unaccounted for. You had some very unusual fact pattern where the police commissioner were to say, you know, because of this very unusual fact pattern, the matrix, you know, the folks who drafted the matrix just never thought about this. It wasn't contemplated. So I think there will be appropriate to deviate from the matrix, but again, it's hard to answer because it happens so rarely.
What steps is the NYPD taking to ensure that penalties are consistent across different precincts and commands, given concerns about uneven applications of discipline?
Right. So I think the matrix is a very important piece of that. Right. That's part of the point. Right. Is to have a single matrix for the department for discipline across the department, and that matrix applies, you know, in whatever command you're in. And then I think you know. Critically, when DAO is in the non-APU cases, DAO is processing CCRB substantiations, and then again, in most cases, not all, but in the vast majority of cases, concurring with CCRB. Those, let's say it's a command discipline, that will go out to the command, but it's at the direction of DAO. Right, you do have that consistency from DAO, which really helps to ensure that you have consistency across the department.
Are we there yet? And if we're not, how close are we? Meaning, like, if we are already aligned with the same thing across departments and commands, that's great. But if we're not there yet, how close are we to getting there?
So I think. In terms of the CCRB cases and DAO's work, I do very much think we're there structurally because of what I just described. I think there's a whole separate issue, which I think maybe is what you're getting at, which is you also have command disciplines that are nothing to do with CCRB now. Command disciplines, and again, these are by definition lower level. We're not talking about charges and specifications. Sort of lower level discipline that happens at the command level, right? The commanding officer in a command finds that someone who works in that command engaged in some sort of low-level misconduct and then imposes discipline. So I think there, because you don't have that centralized DAO sort of controlling across the department, it is happening at the command level. And there, by the way, there are very good reasons to have sort of command level discipline. If you're the CO, you're running a command, it's important for you to be able to unilaterally impose discipline. But I agree with you, or I think it is fair to say that when you're talking about that, you are going to see potentially a lack of consistency across the department because it's individual COs who are making these calls. So I think that is a place where there's still work to be done.
Thank you. I just want to also mention for the record that we've been joined by Councilmember Ressler. Does the NYPD track patterns of officers who have repeated allegations of misconduct? And to what extent does the NYPD evaluate the effectiveness of disciplinary penalties in reducing the occurrence of specific misconduct? And also, does the NYPD believe that current disciplinary penalties are sufficient to deter officer misconduct? And if so, what data exists to support that belief?
Well, there are a lot of different questions there. Certainly, when you have repeated misconduct, I mean, there are various things we're going to do, right? So this is not the disciplinary. So when you have discipline, right, those play out in individual cases. Officers have due process rights. There's a whole structure of both laws and policies that govern those cases. They play out over time. Then you have separately a variety of non-disciplinary processes and procedures that are going on. You know, we have performance monitoring. We have early intervention. We have compliance stat, which is less about individual officers and more about supervisory oversight at the command and borough level. And so, you know, the issues, those things are playing out in parallel, right? Or potentially in parallel. You could have an officer who has multiple allegations. And again, in the nature of things, CCRB's work, the department's work, due process, that can play out over years. That can happen. At the same time, the question is, okay, what is the nature of that person's supervision? You know, are they in the right assignment? And we definitely do look at that.
So you're saying that there's a method of tracking misconduct allegations?
Yeah, no, we certainly have data on that, 100%. And I think it gets complicated, right? Imagine an officer who has multiple allegations that are pending. Nothing's been substantiated yet. Maybe it will, maybe it won't. And that, from a disciplinary perspective, in fairness, there's been no finding against the officer. Nothing's been substantiated. You have multiple allegations, but they're only allegations. And that's going to play out over time. But then separately, the separate question, okay, officers getting multiple allegations, well, why is that? How's this officer talking to people? Is there some area of the law where this officer, needs retraining? Is there a supervisory issue? Is this officer not getting the supervision that the supervisor needs, that the officer needs? Is the officer on the right assignment? So those two things can play out in parallel. I think it is incredibly important, both that we have to let the disciplinary process play out as a matter of law and due process and fairness. I think it is also fair and necessary if you have outliers, officers who are accumulating lots of allegations, you got to ask why and look at why. So I think both of those things are happening.
So the effectiveness of the disciplinary penalties, how do you all, is there a method that you all are using and saying, oh, you know what, this is actually working? And if not, how do we get there to that space?
Yeah, so I think there are a lot of different data sets and inputs that come into that, right? I will give one example, which I think is worth pointing out, and I think it's just interesting. And I want to be clear, I'm not suggesting that what I'm about to say is like the be-all and end-all in terms of the analysis. But for example, if you look at CCR allegations coming into CCRB year to date, allegations are actually down pretty substantially. Allegations year to date are down 12%. And what we're seeing very interestingly is that in certain types of allegations and things that we have sort of focused on at Compliance Stat are down dramatically. So for example, just to give an example, so body-worn camera misuse is something that we have been really focused on. Late activations or early deactivations. It's really been a theme at Compliance Stat. And I think every supervisor in the department knows that when they're coming to Compliance Stat, the thing we're going to focus on is, body-worn camera usage. All right, so body-worn camera, allegations of body-worn camera misconduct are down 28%. In the first half of this year. We've been focusing a lot on working with the monitor on issues in terms of frisks, when they're improper frisks, really focusing on that in Compliance Stat, right? Allegations of improper frisks in the first half of 2025, down 38% with the CCRB. Now, again, that's one data point. And you really can't look at allegations alone. The question is, okay, are these allegations going to be substantiated? It's very complicated. And part of the issue, quite frankly, is you have this long time frame, right? Allegation comes in, you may not know about whether it's substantiated or not by the CCRB for another 15 months, 16 months. That's a long time. It is. But I think looking at the patterns with allegations and seeing some of these decreases, I think is a cause for some optimism.
So just following up, does the NYPD believe that the current disciplinary penalties are sufficient to deter officer misconduct? And if so, what data exists to support that?
Yeah, so in terms of the matrix, I think if we conclude, if we think that matrix penalties are miscalibrated, then we'll change them. The matrix has only been in existence for a few years. And I think one of the things that is an ongoing sort of discussion internally is, are those ranges correct, right? And that's something you learn over time. I think the reality is that you create a matrix sort of in the abstract, but then you have the lived experience of seeing what happens with cases, and you're looking at the facts, seeing what the matrix says, does that actually hold up? That's an ongoing process. So I think, we've made changes to the matrix before. It's certainly possible I imagine we will make changes again, but that's a very sort of fluid, ongoing process.
One stat that does, I think, lead to the conclusion that we're on the right track is that 80% of officers that have faced disciplinary history do not get charges against them again.
And the 20%?
Well, it's not perfect, but again, 80% that are served charges, they don't have a second case where charges were served.
How does the NYPD coordinate with the law department to address the systemic issues that lead to recurring civil lawsuits tied to officer misconduct?
So we talk to the law department a lot, obviously, in a variety of contexts. And that plays out in a variety of ways. So obviously there are certain types of issues, which we're focused on in a very systemic way. Stop, question, and frisk being, I think, probably maybe at the top of that list. We work with the monitor on that. We work with the law department on that all the time, in terms of how to improve our procedures and practices and the like. And then sometimes, we obviously there's data that the law department puts out that's available to the public, available to us as well. And we look at that. And then, frankly, there in there are situations where if the law department's not going to represent, indemnify someone, we're obviously going to look at that. There are times when the law department will call, and we appreciate those calls. Right? They'll say, "Hey, we're concerned about a case that's come in. We're concerned about something that we're seeing." And so those are very important calls to get, and then we engage on those issues. We take a deep dive on those issues.
The most common way a bad stop and frisk is addressed is with command discipline. Does the department view constitutional Fourth Amendment violations as low level?
No, I mean obviously, stop, question, frisk is incredibly important in terms of constitutionality, doing things the right way. We are putting tremendous time and energy and resources in trying to move things forward with the monitor. And I think, I don't speak for the monitor. I'll be very clear about that. The monitor speaks through her reports. I do think if you look at the reports, what you will see is the monitor in the published reports saying that we are very engaged on these issues, working with the monitor and her team to move the ball forward. Compliance, that is a huge part of that. Now, in terms of, when officers make mistakes, I think, this is an area of the law which is incredibly complicated. It is. There are easy cases, for sure, but there is gray, there are hard cases. The law is, you don't have bright line rules. It's incredibly fact specific. There are literally thousands of cases in the New York State courts. There are times when officers get the law wrong, and it's egregious. But there also are times, and this happens, not infrequently, where the officer makes a mistake in terms of, the Fourth Amendment issues, but it's an error, and it has to be corrected. And frankly, if it happens repeatedly, there has to be, significant consequences. But sometimes these are issues where, lawyers might disagree or judges might disagree. I mean, the reality is, in the Fourth Amendment space, you look at the case law, you can have what seem like awfully similar fact patterns, and two different judges come out differently. It's sort of the nature of the reasonableness inquiry. It often does not allow for sort of bright line rules. So I think that has to be factored in. Our policy accounts for that. Obviously, if someone is engaged in significant misconduct or just repeated misconduct, there have to be significant consequences. And quite frankly, the question becomes, are they in the right role if they can't get this right? The flip side is, if someone makes a one-time good faith mistake, we need to acknowledge that for what it is, a one-time good faith mistake. And there are times when the right answer is training. It really depends. And you have to look at these things on a case-by-case basis. I think that's right, and I think that's fair.
Thank you. I'm going to pass it to Councilmember Ressler.
Thank you so much, Chair Salam. Greatly appreciate your leadership here. And thank you, Deputy Commissioner and team, for joining us. Just a few, there are two topics I'd like to cover, so just we'll ask for brevity and responses as much as possible. 45 deaths in NYPD custody over the last 2+ years. It's a phenomenal number, a disturbing number. I'm particularly concerned about what's happening in criminal court. I represent the courthouse in downtown Brooklyn, where we've seen 2 people die this year, including one of my constituents. Do you believe we have adequate medical treatment and medical professionals on site in criminal court today?
Councilmember, I can speak to the department side of things in just candor in terms of sort of more broadly in the system. I don't know the answer either way. And I say that not because like, it's not something that I'm familiar with. So, you shouldn't read into anything in that, my response. I do think that, certainly from the department side of things, look, we have responsibility to prisoners who are in our custody, obviously.
Indeed, our most fundamental and basic responsibility is to keep people alive.
Yes,
Right.
100%.
Yes.
1,000%.
And this extraordinary increase in the number of people who've died in NYPD custody, has that led to a department review? Is there a significant change in policy, enhanced medical services that are being made available to ensure that people are just kept alive?
So again, I mean, every one of these cases is thoroughly investigated by the Force Investigation Division. Every one of them. Any death in custody.
And why is that information not made transparently available to people like me?
I'm sorry, what do you mean?
We want to know what happened. I mean, when people die in my district because of a lack of NYPD oversight, or for whatever reason the person may have died, it seems like we see a major trend here where people are dying in NYPD custody. But I want to know what happened and what's being done to fix it. None of that information is being shared with the council or made available to the public more generally. It's a totally opaque process.
So a few things. Well, I just want to say just for a moment, and I want to answer your question also, but I do want to say, right, I mean, obviously any death in police custody is tragic.
Yes.
There can be circumstances,
Understood.
there are circumstances where it is totally out of the department's control.
Right.
If someone has a pre-existing condition, a medical episode, for example, we can do everything right and the person still dies.
Yes, but in the case of Mr. Nieves, for example, who requested medical help from the NYPD, who requested medical help from his attorneys, who was desperately seeking assistance and was left to die in Brooklyn Criminal Court, I'd like to see the report on what occurred. But we saw this gentleman who was arrested for shoplifting from Whole Foods, who dies in NYPD custody. We saw Ramashvili, who shoplifted power tools and dies in NYPD custody in criminal court, where we see the full diversity of Brooklyn that's going through the criminal justice process coming to arraignment, yet we don't have the medical expertise and assistance on site there. I just don't get it. So Councilmember Williams has a great bill, Intro 98, that would guarantee that medical care is on site to keep people alive, and I really want the NYPD to support it, or I want to understand what your plan is for how you're going to keep people alive, because this trend is profoundly disturbing to me. And I, as the representative for the Brooklyn Criminal Courthouse, I feel a degree of personal responsibility that we need to fix this now. So it sounds like this is not your wheelhouse, but I do want to say that I will be following up the commissioner's office, and we want to get clear answers on what's happened in these recent cases and what's being done to fix it. With that, I'd like to shift gears more directly to your wheelhouse for my last minute and 24 seconds. So I am just very concerned that we've seen a 60% increase in the number of complaints against the NYPD that have gone to the CCRB since Mayor Adams took office, from about 3,483 to FY25, where we saw 5,575, 60% increase since Mayor Adams took office, annual CCRB complaints. I'm concerned the number of substantiated complaints has nearly tripled since pre-COVID. So when we go back to FY20, 370 annual substantiated complaints, now we're well over 1,000 annual substantiated complaints. And then I'm just as concerned that we're seeing an increase in non-concurrence, where we're seeing the commissioner overturn complaints in much larger numbers than ever before. 783 times the NYPD overturned the CCRB recommendation in FY25 for misconduct by a police officer. So I recognize it's a big department. I recognize that overwhelmingly men and women of NYPD are doing good work every day to help keep our communities safe. But when there are people that act the wrong way, that are disrespectful to our communities, and misuse their force and their responsibility, there has to be accountability. And for 783 non-concurrences to occur just this past fiscal year is deeply concerning to me. So I would just like for you to help me understand. We're seeing a huge number, an increase in substantiated complaints. It's a huge number of total complaints against the NYPD, 60% since the mayor came into office. We're seeing 3 times as many substantiated complaints where the CCRB found the officer did the wrong thing relative to pre-COVID, And we're seeing the non-concurrence rate is 5 times higher than it was pre-COVID, when there were 150 cases overturned in FY20 by the NYPD CCRB recommendations. This year, 783. Doesn't that send a message to NYPD officers that they can get away with whatever they want, and if they act irresponsibly or are responsible for misconduct or rude or actually harmful to members of my community, that there's no accountability whatsoever?
So let me respond to, there are a few different pieces there, and I want to address them. So first, with regard to the concurrence rate or non-concurrence rate for fiscal year 2025.
Yes.
What that's doing, so really what you're talking about there is the second half of 2024 and the first half of 2025.
Fiscal
Roughly.
year.
Yes.
It's the fiscal year.
Yeah.
Yeah. That's
No,
we
but-
live in
but-
fiscal years.
No,
sir.
of course. But so it's really, what that's doing is obscuring really, you have two very different stories. If you look at the data for the second half of 2024 and the first half of 2025, it is radically different in terms of the concurrence rate. So if you look at it, so just, again, looking at the CCRB's data on concurrence, right? And then taking out the short SOL cases, because we've stopped doing that. I think that's fair.
Let me do this
wait,
differently.
wait,
No. You're saying that things have dramatically improved over the last 6 months of FY25 of calendar year of the first. You're saying over the first 6 months, the latter 6 months of FY25. So the first 6 months of this fiscal year of this calendar year.
yes.
Excuse me. Things dramatically improved. How many non-concurrence decisions were overturned by the NYPD in the first 6 months of this year? Total.
Oh, I'm getting that for you.
Please.
Right. All right. So
Of this calendar year. First 6 months of this calendar year. How many?
I'm going to give it to you. So I'm using, I want to be clear about what I'm doing. I'm taking the CCRB data. So it's a CCRB, not the PD saying there was concurrence. The CCRB saying there was concurrence, okay? I'm excluding the short SOL cases. We did do quite a few of those at the beginning of the year, but we stopped. And then, so out of the CCRB finds a concurrence rate using that of 91% in the first half of 2025, okay? Their data says discipline, they recommended some form of discipline against 643 officers. And the NYPD did what the CCRB recommended in terms of the disciplinary recommendation in 585 out of those 643 for a 91% concurrence rate, right? Now, I want to be very clear. In the second half of 2024, it wasn't 91%, not even close. But that the fiscal year is actually obscuring the shift we've seen from the second half of 2024 to the first half of 2025. So that's one
We'll
point.
dig in.
Yeah, no,
in
and just so you know
more
where
to
it's
the
coming
data,
from.
but I just want, go ahead.
So it's coming from this is from the CCRB semi-annual report, 2025, page 45, if that helps.
No, what I'm looking at, as you probably know, is the Mayor's Management Report, which was
Yes.
released less than,
I'm
what's the
aware.
date today? The
I-
22nd,
I
5
know what
days
it
ago.
says, yes.
So you know what it says. That's the data I'm citing. It's deeply
No,
troubling
100%.
data.
And-
You're claiming that things have dramatically improved. So
Well, I'm
let's
saying
just,
that
for the argument's sake,
be clear that the CCRB is saying that.
well, I haven't seen that data. All I'm going on is the data that was released 5 days ago by the CCRB and the mayor's office, claiming that there is a dramatic 783 non-concurrence decisions where the NYPD overturned the CCRB's recommendations over the previous 12-month period. So you're saying it's 60 over a 6-month period, which is, close to, which is a significant decline. If it's true, I'm happy.
If I may, can I think it's your other
Please.
question about the increase in complaints? So I understand what you're saying, of course, and I understand the question, but I do think there's a very important point here that I think is getting lost a little bit in the discussion. I think needs to be at least part of the discussion. If you look at the data, CCRB's data on complaints coming in, you go back to 2009, it was like over 7,000 complaints. The number's falling over time. It's not a straight line, but it's trending down.
During the de Blasio
trending
years,
down,
yes.
Trending down.
And then they increased significantly during the Adams years, just
No, but
coincidentally.
there's something else.
Yeah,
But
please.
there's another piece.
Yeah. No, I was here for those years.
Another piece that I think is very important, which is the spike is at the beginning of 2023. You see it in the graphs. It's actually quite striking. You see it on an annual basis, even on a monthly basis. In 2023, beginning of 2023, everything goes up. At the end of 2022,
Eric Adams' first full fiscal year in office. Yes.
If I could just
Please.
answer your question, please. what happened at the end of 2022 is that the CCRB actually implemented its new regulations for its expanded jurisdiction. And that includes body-worn camera misuse, bias-based policing and racial profiling, and the ability to self-initiate. What you had at the end of 2022 was a very significant increase in CCRB's jurisdiction. As a statutory matter, it happened earlier, but in terms of the regulations actually being in place and CCRB actually being able to do these cases, it only happens in October of 2022. And so all I want to say, and I'm not saying this is the only cause, I'm not. But if you take an investigative agency and you dramatically expand its jurisdiction, that is going to contribute to an increase in complaints. I'm not saying that's the entirety of the increase, but like that has to be part of the story. If you expand jurisdiction.
With Deputy Commissioner, with all due respect, we've seen the number of civil summons dramatically increase. We've seen the number of criminal summons dramatically increase. We've seen the number of arrests dramatically increase. We've seen the number of incarcerated people dramatically increase since Eric Adams came into office. Those increased engagements with New Yorkers, especially Black and brown New Yorkers, have led to more complaints against the CCRB. It's more complaints against the NYPD. There's no NYPD. There's no question that NYPD has shifted their approach to policing during this administration, and as a result, more people are complaining about misconduct. My issue is that the CCRB hasn't had the resources or the capacity to actually investigate these complaints. When the CCRB came before this committee during our budget testimony this past fiscal year, they told us that whenever an officer curses at someone, acts disrespectfully to somebody, does all kinds of really problematic things, they just close the case automatically because they don't have the capacity to investigate. We pushed, and thanks to the leadership of Chair Salam and most of all our speaker, we secured additional resources in this budget for the CCRB, and I hope they will have more capacity to look into allegations of misconduct and work to hold the NYPD accountable. But we all know how the system works. As a result of state law, it's ultimately up to the police commissioner. And if she's overturning 783 cases in a year, that's a lot. I'm happy to hear about the progress. We will do our own due diligence on the data. The chair has been incredibly gracious to let me go long, and I want to thank you, Chair, for that.
Chair, if I may, just let me say that 1 minute really quick. Councilmember, you had asked about the CCRB data and the increase in complaints, particularly in 2023. I do think the expanded jurisdiction needs to be part of that discussion. The other point I think also just needs to be made is with regard to, if you look at the data on force allegations, what happened from 2022 to 2023, and it's continued on for several years, is it is true that the number of force allegations went up very significantly. The substantiation rate, CCRB substantiation rate for those force allegations fell from around 12 to 13% to around 5 to 6%. Now, just if I may, 12 to 13%, frankly, is pretty low. 5 to 6% is like really, really, really low. And all I'm saying is, as part of this discussion, it is important, I think, to acknowledge that yes, you had this increase in allegations, but you also had a significant decrease in the substantiation rate.
And I would argue that you have an agency that has been like deliberately and severely under-resourced, where the investigators are unable to conduct investigations with the time and care that is necessary, and when even they're only substantiating 5 or 6% of cases, which is troubling. Use of force cases.
Force allegations.
I'm concerned that we have such a high percentage of these cases being overturned by this police department over the past 4 years. So even when they're only substantiating a relatively small percentage of the cases because they have such few staff, because they're spread so thin, because they have such limited capacity, still the NYPD is overturning them at alarming rates. Thank you very much.
Thank you. We'll now hear from Councilmember Caban.
Thank you. I'm going to follow up a little bit on the council member's line of questioning. I do want to say that I'm glad that I heard the DOI is going to be doing a report on in-custody deaths. And I know that the Legal Aid Society and others sent a 10-point plan to the NYPD, so I'm hoping that they take that seriously and implement it. We know about this alarming string of NYPD in-custody deaths. Are officers that were responsible for the well-being of people who died are they currently suspended pending investigation, or are they on modified duty? Anything else?
So again, I'm not going to speak to any one particular case. I think the question becomes, in any particular case, is there a reason to think, believe, conclude that an officer engaged in misconduct? I do want to emphasize what I said before. The fact that someone dies anytime someone dies in police custody, that is a tragedy. It does not mean that the officers who responded or who had the person in custody necessarily did something wrong.
I'm asking though, right? I'm not saying divulge the details of any particular, I'm asking, are there any officers currently suspended pending in any investigations related to any of these deaths?
I do not know the answer to that question.
Can you get back to this committee with that information?
Sure.
And currently the FID is investigating those deaths like you've mentioned. Will you commit to making the findings and the records of those investigations into any and all of those in custody deaths available to the public once they're done?
I can certainly say that we will share with the public the conclusions from those investigations. I can't say that I'm going to give you the work product that goes into that, but if you're asking, are we going to be transparent with the public about the conclusion from FID? Yes.
Not just the conclusion, it's like we want to see the math, right? Not just the end result, but how you got there. So that's what I'm asking for a commitment on.
So today you're asking that we're going to include, sort of necessarily produce like any and all materials in connection with an investigation.
I didn't say that. I didn't say that.
Councilmember.
That wasn't my question, right? And now I'm clarifying and saying, listen, I want something beyond just where you landed, but to show how you got there. Now, that doesn't mean that I'm asking for an 1,000-page document with every single piece of information, but I'm asking, will the NYPD show the public their math?
And when you say their math, do you mean, I'm not sure what you mean by that.
Will you show the things that led to the final decision?
Well, I can tell
The
you,
framework, the
Councilmember,
principles, the policies that were implicated, and say, hey, this is how we got here. This is the framework we're operating under, so you know how we got to this answer.
Yes, what I can tell you is that we will be transparent with the public about our findings and why we concluded what we did. I can tell you that.
Okay. I don't think that's good enough. Moving on, what training do officers receive to identify when a person in custody needs immediate medical assistance?
So we will give you that information. Again, Commissioner Rahman and I are not the right people to answer that question. You're talking to the lawyers here, but yes, we will send a letter to the committee, to you, walking through kind of what that policy is.
Can you answer this? So, not knowing what that training is, and is it a failure to render medical aid, right? Is that considered serious misconduct?
If an officer understand that someone is in medical distress and they failed to give aid, yes, that is serious misconduct, 100%.
Okay. And then what are the consequences for failing to render medical aid?
Extremely serious discipline. I mean, I think rising potentially to the level of termination. If an officer understood that someone was in medical distress and stood by and did nothing, and particularly if that resulted in someone's harm to that person or even death, that is incredibly serious misconduct.
And at this moment, you don't know whether any of the officers that were present during the NYPD in custody deaths that we have referenced, you don't know whether they have been put on modified duty or suspended or anything pending investigation.
I do not know.
But you will get that information back to us.
I will.
Okay. How many complaints have you received over the past 3 years for failure to render medical aid?
We can get that. I don't have that here, but we certainly could get that for you.
Okay, and then in addition to that, just as a follow-up, when you get that information and give it to the council, I'd love to know how many of those complaints there was a serious injury or death that occurred in NYPD custody. Are FID investigations into in-custody deaths automatic? I think you said it would, but I want to make sure that you're clear on that they are automatic, correct?
There's a death in custody, FID is investigating, period.
And does FID retain jurisdiction over the investigation if it's for failure to provide medical assistance?
I believe the answer is yes. If you have a death in custody, FID is going to look at that holistically, including if an officer failed to provide medical assistance.
Okay. Chair, if I may, a couple more questions. Thank you. Does the law require NYPD to publish the data that I'm talking about to the open data portal in New York City?
Which data are you referring to?
The data that I just asked about. So like the number of complaints that have been received, what the nature of the injury was, the investigations, all of those things, the penalties. Like is that published in the open data portal? does the law require NYPD to publish this into the open data?
Again, I'm not sure I totally understand the question. I mean, in other words, if you're talking about like allegations coming in, CCRB publishes that material. If you're talking about, charges and specifications and disciplinary outcomes, that is certainly public.
So in relation to failure to render medical aid, is there any law that exists currently that the NYPD must publish certain data to the open data portal? And if that's the case, what do they publish and what doesn't currently get published?
Yeah, off the top of my head, I do not know the answer to that. Obviously, we can get an answer to that very quickly, and we could let the council know. But you're asking about, just to make sure I have the question right, you're asking about, in particular, about failure to render medical assistance.
Yes.
Are there reporting requirements? If so, what are they?
Yes.
Okay, we will get back
Great.
to you on that.
And then my last question on this is that why has NYPD decided to contract a third-party vendor, Rock Daisy, to build and maintain the NYPD officer profile portal instead of publishing an open data portal, NYC, and publishing on that portal?
I know nothing about this. I don't know.
Okay.
What you're talking about.
Well, I would like to know the answer to that. Until recently, the data wasn't posted on open data portal in New York City at all. So I want to know why the NYPD would prioritize utilizing a non-secure vendor instead of complying with New York City's open data law, and what the total cost of that is. I think that's super relevant, Chair. That's the last of my questions, but I wanted to end with a comment. There was on the record, I think one of my colleagues asked about what makes the commissioner sort of like, what talent do they have or what makes them special in being able to make a determination that that they could, with the confidence of the public, overturn the decisions made by two independent oversight bodies. And I just want to put this on the record to think about. We should also think about why the commissioner should not be the person who does that. And specifically, I think it's in part because they are the commissioner of a workforce with a union that is the only union that they have to lead and keep under control, right? That is the only union that bargains for a right to kill without license, right? With impunity, without discipline. And so balancing the struggle of maintaining control of the largest police force in the country and dealing with the biggest, most powerful union that literally is the only union that collectively bargains to be able to get to kill people without there being a consequence, and saying, well, should this person, and under those circumstances, have the ability to overturn the independent fact-finding judge and the CCRB? And I would submit that she probably shouldn't. Thank you.
I just do want to say, just for the record, right, the law, not collective bargaining, the law speaks to officers' use of force, officers' use of deadly force, when it is justified, when it is not.
Thank you. I'm now going to pass it to Councilmember Joseph.
Thank you, Chair. I just want to do a really quick follow-up. Should someone not automatically be investigating the death? And does the commissioner or the mayor requested that the death of Sanaya Cheatham be investigated by the department? Yes or no?
Can you just repeat the question? I'm sorry.
This is the follow-up similar to what my colleague just said. Should not automatically be investigated when someone dies in custody? Or does the mayor or the commissioner have to request that?
So I know you said yes or no, but I actually can't do this one yes or no. I'm sorry. So again, FID will always investigate every death in custody. I also should point out the State Commission of Correction does have the authority and mandate to investigate deaths in local correctional facilities, which would encompass some, though not all, of the cases that you're talking about, so that they do have a mandate there. And then again, DOI, as I understand it, is going to be looking at these cases.
All right, one quick question about your Q team. I know it was designed by focus on community complaints made with 311. Is there data kept on pickup jobs that are outside of the 311 calls?
There may be. I'm just not sure. I think there is. I'm not the neither Commissioner Rahman nor I are really sort of the experts on the Q teams.
But you can get that data to the committee, right?
Yes.
You got a lot of stuff to give to the committee, and we'll be waiting, and I'll be watching. Thank you.
Councilmember Ariola.
Thank you. I want to kind of flip the narrative because we're talking about a lot of information that's being shared that would provide information for the person who's incarcerated, the person who's been arrested. But I'd like to know what the department is doing to facilitate trial dates for officers who there has been a substantiated evidence, and they're waiting sometimes 3 years. And in conversation with unions such as the Lieutenants Benevolent Association, some of their lieutenants are waiting 3 years for a resolution, and they've been pushing for a trial date.
Yeah. Yeah, no, it's a fair question. Sorry. So, as I was saying before, once someone is asking for a trial date, our trial judges are under a mandate to do that very quickly. The delay here is not coming from our trial judges. They have a very busy docket. They're scheduling things 2 to 3 months out, which I think is actually pretty reasonable in terms of trial scheduling. Again, there is a challenge here, which is that in the APU cases, the charges and specifications cases, we are not the prosecutors. CCRB prosecutes those cases. And to the extent CCRB, as the prosecutor, is, for whatever reason, choosing to delay. And I'm not weighing in on whether they're good reasons or bad reasons, but to the extent CCRB is, for whatever reason, not expeditiously moving forward with a prosecution, that's not something that we have control over in this process. So I think that piece is really a question for CCRB.
Thank you.
Thank you for your testimony. That concludes that portion of the hearing.
Okay.
Thank you.
Thank you.
Thank you. We're going to just take a brief pause and then hear from CCRB. You said we're ready?
Yeah, whenever you are.
Thank you for joining us. We will now hear from the CCRB. I'll pass it to committee counsel to administer the oath and swearing in.
Thank you, Chair. With us from the CCRB, we have Jonathan Darsh and Dr. Mohammed Khalid. If you could please raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth before this committee and respond honestly to council member questions?
I do.
Noting for the record that all witnesses answered affirmatively, you may begin your testimony.
Good afternoon to you, Chair Yusuf Salam, and to the entire committee. Thank you for the privilege and honor of being here today. My name is Dr. Mohammed Khalid, and I am currently the interim chair of the Civilian Complaint Review Board. First, I wish to take a moment to read you a few headlines from this year in the papers from different parts of the country. From St. Louis, city tells police oversight board to stop providing oversight or face penalties. From Iowa, Iowa City to dissolve Community Police Review Board to comply with the new state ban. From Florida, civilian oversight in Florida crumbles after new law kicks in. Across the country, we are seeing more stories like these, but here in New York City, we are seeing more complaints of police misconduct. Police oversight is seemingly under attack, but it is also more needed more than ever. As the nation's largest civilian police oversight board, our most important role is to work on behalf of the New Yorkers to provide accountability and oversight of the New York City Police Department. But we also serve as an example for the rest of the country working to achieve the goal of better police-community relations. Others look to us as a model that they can follow. How do we do this? Perhaps the most importantly, this council proposed charter revision commission would help us in ways that could profoundly impact police oversight here in New York. But crucially, they would also serve as an example for the other cities around the country. First, the proposal modify our minimum budget from a headcount-based model to a model based on the personnel cost of the police department, which will help our work dramatically. Even as the number of the police officers has grown, the CCRB has not been able to keep up. This new model would revolutionize our ability to reduce the time it takes to investigate cases. Secondly, the proposed to add 2 new additional members to our board, one designated by the police department and appointed by the mayor, and one appointed by the public advocate would further help our agency more efficiently handling our sizable workload. This would also help us by expanding the diversity views on our board, enabling us to demonstrate importance of thought leadership and the discussion of our counterpart around the country. Lastly, the proposed to alter the quorum requirement to a simple majority, not including vacant seat, will allow the board to convene more often and at a greater convenience. Once again, giving us the tool to more efficiently complete the vital work that our agency undertakes. It is hard to overstate how transformative these proposals would be to CCRB. We are pleased to see the City Council's support of our mission and its desire to back that support up with the specific policies. We appreciate the work of the Police Commission to strengthen the local democracy. These proposals alone will not enable the CCRB to fulfill its mission to receive, investigate, mediate, hear, make make findings, and recommended action on complaint against New York City police officers. We are the largest police oversight board in the country, and the scale of our work is ever larger in 2024. We recorded the highest number of complaints in over a decade. Many of these complaints represent the worst days of someone's life, whether they are being accused of a crime, suffering a mental health crisis, or simply going about their business. At present, two things constrain our ability to fully represent the people of New York as they request accountability from the New York NYPD for alleged misconduct. This first is that we do not have direct access to all the information our investigations require. For example, after we begin investigating a complaint, our investigator must request access to body-worn camera footage from the police department. While this delay has decreased over time, it still represents a significant roadblock in completing our investigation in a timely manner. The same is true for the other type of records within the NYPD that may come up during an investigation. And many of the records we do request are sealed under statute. This means legally we cannot view them, and we may not be able to investigate serious allegations. We cannot truly begin our investigation in full until we have access to all necessary records. Having direct access to all records, including access to sealed records, would make the agency much more efficient and be able to fully investigate our cases. The CCRB having direct access also means the CCRB being exempt from New York State sealing statute. Second, the CCRB is empowered by the law to make a recommendation for the discipline to the police commissioner, but we do not impose that discipline ourselves. We have seen this recently in CCRB cases, which as Lieutenant Jonathan Rivera killing of Alan Phillies. Without final disciplinary authority in these cases, we investigate even the most serious substantiated allegation of police misconduct cannot go unchecked. When this happens, public trust is weakened. People do not trust the CCRB, and they do not trust the other system of public safety. This weakening of this public trust also weakens the relationship between the police and the people they serve. This is exactly what the CCRB was designed to help fix. It is a great privilege to lead the CCRB as an interim chair. Every day, I see New Yorkers who my agency serves walk down the street, waiting in line at the store, even sitting across from me in the hearing room right now. We are pleased to have partnered in this work throughout the government, including in this chamber. We believe that together we are able to be voice of accountability on behalf of the New Yorkers and to be model for other cities around the country to follow. New Yorker lead, and we will always lead. Thank you again for your opportunity to join you here today at this vital hearing. I look forward to your questions.
Thank you. So I want to begin my line of questions by asking, how have staffing reductions and funding shortfalls affected CCRB's backlog and case closure times?
Thank you, Chair. The CCRB's staffing shortfalls led us to implement a policy called the Strategic Resource Allocation Determination, in which the agency closed complaints that had certain types of allegations. And we've closed approximately 4,000 complaints without any investigations that would normally have fallen within our jurisdiction. As a result, some of our case processing times have gone down, but it is still a major obstacle that the agency has in investigating complaints that we are not staffed at the level we need to conduct our investigations and our prosecutions. The CCRB is truly appreciative of the work that council did to increase our budget and our headcount. We've already have a new investigative class of 12 investigators that has begun since the budget was implemented, and we plan to have at least one more class in calendar year 2025. But we are waiting until we actually have the folks on board and able to investigate complaints before we make changes to the strategic resource allocation determination. And there's another area in which budget questions come up. One of your colleagues asked a question in the prior panel to the NYPD about trials and how long it takes to get a trial. Right now, the average caseload for administrative prosecution prosecution unit team member is 1,100 cases. And so we are waiting on approval to hire 3 more prosecutors, and we've been working diligently with the department to get cases on the calendar and get them tried as soon as possible. But it is a real challenge, and we are striving to meet it and get cases scheduled for trial and resolved as soon as possible.
Thank you. CCRB relies on NYPD for access to critical investigative materials such as body-worn camera footage. So to what extent does CCRB feel constrained by its reliance on the NYPD for evidence? And what additional authority or access to evidence would most immediately strengthen your investigations?
Yeah, go ahead.
So the CCRB needs, as Dr. Khalid testified to, direct access to the NYPD's records. In order to have that direct access, we need to be exempt from New York State sealing statutes. There's a bill in Albany that sponsored by Assemblymember Cruz and Senator Bailey that would exempt CCRB from sealing statutes in a way that would make direct access possible. And that is a real priority for this agency going forward. The NYPD has made significant strides in getting CCRB information in a timely way. There is a memorandum of understanding that between the two agencies regarding sharing information from cases that were investigated by the Force Investigations Division. That was signed, I'm pretty sure, at the end of 2024. And that resulted in sharing information in a way that the CCRB was able to close the investigation into the killing of Win Rosario before the expiration of the statute of limitations, which is something that is very, very difficult, had been very, very difficult to do in cases resulting in investigations resulting from the deaths of civilians prior to the signing of that memorandum of understanding. Also, the times in which the NYPD turns over body-worn camera footage to the agency have gone significantly down. This is a result of changes made structurally to the CCRB and the NYPD that committed resources on both sides into requesting and obtaining body-worn camera footage and other documents, other information from the department. And it's had real progress. I don't want to diminish the nature of the cooperation we've received from the NYPD, but the CCRB needs direct access and we need to be exempt from sealing statutes, as the chair testified to.
Thank you. I'm now going to pass it to Kaban to ask her questions.
Thank you very much. I know we've been asking last several hearings about being able to provide y'all with direct access to NYPD records and databases, so it's not surprising that it's come up again, and I think that's incredibly important. I want to start by asking, how does CCRB go about enforcing any of the various MOUs with NYPD if NYPD violates the terms or delays producing the records subject to an existing MOU?
So if the CCRB and the NYPD have a dispute over interpretation of the MOU, we try and talk to one another and have conversations at an executive level to the two most recent memorandums of understanding were over following the discipline matrix and sharing information from Force Investigations Division investigations. Oh, and also data sharing for the racial profiling unit. Of the first two that I mentioned, there have been no issues, so that it hasn't even come up to have that higher level conversation. With regard to data sharing, there was a meeting to work out that memorandum of understanding between the administration, the department, and leadership at the CCRB. And then there have been continual meetings with NYPD Legal since then, and Deputy Commissioner Gerber's team has been very open to listening and trying to work out ways in which we can resolve issues that have come up. And recently, we discussed actually having conversations about making changes to the data that we are given under that MOU, and the department has shown a willingness to enter into those negotiations and move forward in making changes.
Thank you. Is there something that this council could do to ensure that NYPD complies with any MOUs that are currently existing with CCRB?
So I don't know of any, but that doesn't mean that there aren't any, and so we'll get
Think
back to
about
you.
it and then get back to us.
Yes, ma'am.
I know this was said before, but I just want to make sure, again, it's really clear for the record. I think you were asked, like, what is the thing that would make a big difference? And it is that direct access to these records and databases. Is it fair to say that being able to have direct access, and like, let's use body-worn cameras as the example, would it help address the problem for potential compounding delays with requests for records? If you had direct access, would it save more time? Would it reduce some of the strain on your resources if direct access were granted? Is it fair to say that that would be the case?
So I think the number one way it would change things is it would improve the public's trust in the system. It is unclear whether or not those would actually make things go faster or reduce the stress on CCRB's resources, because that is a significant amount of work that the NYPD is doing that would have to be done by CCRB. So I don't want to minimize the amount of work that is being done by the department, but I think the work that would have to be done by the CCRB would be worth it for the increase in public trust.
Heard. And obviously the need is more resources, more staff. Trying to think of what else I want to ask. Does CCRB have the requisite experience and knowledge to investigate NYPD in custody deaths? We've spent a lot of time talking about in custody deaths.
I think currently we don't have, whatever the law permits that we investigate any CCRB related cases. The custody issue, if it falls within jurisdiction, then we'll be happy to do it. But if it doesn't, then Probably we will not be able to, but should it happen, we'll be happy to investigate.
As Dr. Cooley just said, the CCRB is currently investigating some complaints that we've received about deaths in custody. Mr. Chair, do you mind if thank you. We don't systematically investigate every complaint of a death in custody. There was a recent letter sent by the Legal Aid Society to the Department of Investigation that recommended the CCRB routinely initiate its own complaint into all deaths in custody. That would require a significant increase in resources for us to do that. And I think if you look back, in 2021, when we were discussing whether the CCRB could handle racial profiling and bias-based police complaints, I said we would need a unit of approximately 50 people to do those complaints. Right now, we have a total of 22 personnel investigating those complaints. To systematically address every death in custody, we heard the numbers during the earlier session are significant, would require additional resources, and we haven't even been able to get to the point we're able to do the complaints currently in our jurisdiction. So it is,
Right.
While it is within it would be a less significant lift for us to take those allegations on than it was for racial profiling. It would still be a significant change. And we're just not prepared at this time. We just got the letter late last week to give you an estimate of how much more resources it would require for us to do those type of investigations.
And I mean, this is a side, but Chair, may I have just an extra moment? This is kind of an aside, but I think it also makes the point earlier between the questioning that Councilmember Ressler did in terms of the story. We can tell with the data that's given, because you guys do not have the resources to take up and investigate every complaint that comes in, right?
Correct.
Okay, thanks. In terms of training and retention, and then I'll be done. It's just a couple more questions. But how long does it take to train CCRB investigators?
So the initial training is approximately 6 weeks long, but generally speaking, they're working under close supervision of their squad leaders and supervising investigators for at least 6 months before they really have the training wheels taken off, so to speak.
Right.
So it is. And as level 1 investigators, they are seeing the least complicated of the complaints that the CCRB receives.
And so, in order to really have also an impact, is that those folks have to stick around a while. I'm going to liken it to my experience as a public defender, right? Like when I was a baby lawyer, the first couple of years of my practice, I could only do the misdemeanors, and so it didn't solve for the problem that we had. More seasoned attorneys taking on. It was going to be years before I could help with the problem of more experienced attorneys having way too many felonies, violent felonies in their caseloads. It's kind of the same as that, right? It takes some time for them to be able to take on some of these more serious cases. So that leads me to my next question, which is, what's the attrition rate of investigators?
It's approximately 4%.
Okay. And what would improve retention so that the CCRB is able to retain and invest in experienced staff to carry out the mandate, to be able to take on, more complicated cases, things like that?
I think, again, it comes to that promoting the investigators, we need more resources. And in order to keep them, we have to give them the promotion and better resources to provide them, and I think that will really help us reducing the attrition rate. John, you want to add something?
The starting salary for a level 1 investigator is $49,148 a year. And
Nobody can live on that in New York City.
so I think,
You didn't say 49,000.
yes, but that's a negotiated amount between DC 37 and the city. And so it is something that the agency has made clear that we think needs to be a higher number. The other issue is the CCRB is submitted to, I'll be honest with you, I don't know exactly where in the process we are. We are asking for the creation of a level 4 investigator. Right now, there are currently 3 levels of investigator because we think that having an additional level of promotion available to our investigators would encourage people to stay around longer, especially if you have a seasoned investigator who isn't interested in managing other people, but is a high-quality investigator who can handle extremely complicated complaints.
Thank you. Thank you, Chair.
Definitely concerning. How has the discipline matrix improved or failed to improve consistency between CCRB recommendations and NYPD outcomes?
So the matrix has improved consistency in CCRB recommendations. I think there is still, I don't think it has any effect on the department's concurrence and discipline rates, because when they do believe discipline is merited, they also use the matrix. So I don't believe they're ignoring the matrix, but there is a difference in whether they feel discipline is warranted or not, and the matrix can't control that.
High-profile cases demonstrate that NYPD often rejects or downgrades CCRB's recommendations. Do you have an opinion on what tools or authority CCRB needs to ensure its substantiated findings lead to meaningful accountability, especially in cases of serious misconduct?
Chair, looking at the current conditions, what is happening in few of the cases, I think time has come that the city council or whatever the authorities are, the whole discipline authority should be giving to the CCRB for a proper disciplinary action instead of giving to the police commissioner. We have seen in cases that this case was the deputy police commissioner Maldonado did a case that it was told that the police officer should be dismissed. But our recommendation went and the police commissioner turned the other way. So I think that we investigate cases, we know what's in there. And I think it's plus 30 years that this agency was established. And now I would characterize it this way. We are tiger, but we don't have the teeth. So I think it's a time that we should be given the full authority of investigating and making determination what we should be giving to the police officer, their discipline-wise. So it should not be given everything to the police commissioner to make a decision. I think 30 more years have passed. It's time now that we should be doing the disciplinary action as well, since we investigate police department personnel.
I think we should take those recommendations and try to become a perfect world regarding those things. And I'm not sure if you have any secondary questions. So that concludes our
Thank you, Mr. Chair.
thank you as well. Thank you. I'm now going to open up the hearing for public testimony. I remind the members of the public that this is a formal government proceeding and that decorum shall be observed at all times. As such, members of the public shall remain silent at all times, and the witness table is reserved for those people who wish to testify. No video recording or photography is allowed from the witness table. Further, members of the public may not present audio or video recordings as testimony, but may submit transcripts of such recordings to the Sergeant-at-Arms for inclusion in the hearing record. If you wish to speak today at today's hearing, please fill out an appearance card if you have not already done so with the Sergeant-at-Arms and wait to be recognized. When recognized, you will have 2 minutes to speak on today's hearing topic. If you have a written statement or additional written testimony that you wish to submit for the record, please provide a copy of that testimony to the Sergeant-at-Arms. You may also email written testimony to testimony@council.nyc.gov within 72 hours of this hearing. Audio and video recordings will not be accepted there. I now call the first panel.
We'll first hear from Linda Tagini from the Commission on Racial Equity.
Hi, good afternoon. My name is Linda Tagini. I serve as the chair and executive director for the New York City Commission on Racial Equity. We are an independent commission, and I lead CORE in partnership with 14 commissioners and 12 staff members. The primary means through which CORE fulfills its mandate is by shaping, evaluating, and monitoring the city's biannual racial equity planning process, whose centrality to our work remains undiminished by the mayor's ongoing delinquency in releasing it. To ensure that this process is guided by the priorities of those who have been historically underrepresented in or underserved by government and its processes. CORE has engaged over an estimated 7,000 New Yorkers and supported 300 local community conversations, raising recommendations for what actions government must take to improve the well-being of communities harmed by racism and social injustice. These conversations have revealed a palpable frustration with the lack of accountability for a history of the New York City Police Department actions resulting in the killing, sexual assault, harassment, and false imprisonment of Black and brown New Yorkers. Of the 4,212 New Yorkers surveyed during our first round of engagement, 83.6% agreed that holding police officers accountable for the harm and abuse they commit is critical to improving the well-being of New Yorkers, leading CORE commissioners to vote in November of 2024 in favor of a Community Equity Priority 16, ensure all city employees and their agencies, including the police, and social service providers are held accountable for any harm and abuse of power. Now in our second round of engagement, we've received feedback from 4,550 residents about the relative urgency of each. Our preliminary data shows that 94% of respondents believe that CEP 16 is an urgent task for New York City government to address. Considering that my time is almost out, I am going to just quickly share the recommendations from the Commission on Racial Equity.
Sure, thank you.
Allow for the Civilian Complaint Review Board to have final authority over police officer discipline. Develop and implement a police officer and member of service discipline matrix that is transparent, publicly available, and agreed upon by survivors of police violence and family members who have lost loved ones to police violence and communities harmed by racism and social injustice. Require the NYPD comply with existing laws to turn over footage and information to existing oversight bodies to ensure timely and complete investigations to police misconduct. Institute accountability practices that account for the well-being of survivors and family members harmed by police misconduct through the investigation and after a decision has been rendered. And lastly, conduct an anti-racist review of 911 scripts to ensure that racial bias and bias against people experiencing mental health episode yields a response that is trauma-informed and encompassing of all the services that New York City has to offer, not just the police responders. I do provide additional recommendations that align with the New York City Council's charter to strengthen democracy, and that is noted in my testimony. I do want to add before I close out that earlier today we heard NYPD use a phrase that there is such a thing as a good faith mistake by our officers. I want to be clear for the record that murder, rape, assault, false imprisonment, allowing our people to die in custody can never ever be considered a good faith mistake by any human being, especially those who are paid by New York City tax dollars to serve the public. Thank you.
Thank you for your testimony. Yes, I'm sorry. You can.
I
hold
just
for a
quickly want to
second.
thank you for your testimony, and to that point, even in the context of mistakes in the workplace, and this is being generous to the NYPD, whether intended or not, we all experience consequences for mistakes that are made, and have guardrails to make sure that those same mistakes don't happen again. So I just wanted to put a finer point on that and appreciate the work that you're doing in your testimony. Thank you.
Thank you.
Thank you. Next, we'll hear from Nisar Bhuyan and Sami Feliz.
Just press the.
Sorry.
Thank you.
Good afternoon. I'm Nasar Bhuyan with This Is Rising Up and Moving Drum, and Jesse worked closely with Win Rosario's family, and Win's family was planning to testify today, but were unable to take off work. I'll read their testimony. My name is Nutan Eva Costa, and I am Win's Rosario's mother. No mother should ever have to deal with the pain and unimaginable loss of watching their son gunned down by police in what should have been the safety of our home, while I tried to protect him from the dangerous police. As you may know, my son Win was a teenager when Officers Salvatore Alonghi and Matthew Cianfrocco tased him multiple times and shot him 5 times in less than 2 minutes from when they got to our apartment. It was terrifying. I was relieved to hear that the NYPD served the CCRB's charges on Alonghi and Cianfrocco, but I wish me and my family and so many others did not have to fight to make that happen. Alonghi and Cianfrocco should already have been fired, and it's painful that we still have the whole discipline process ahead of us when they killed my son in cold blood. It's wrong that the NYPD never updated us about their FID investigation in the past year and a half. And now they seem to deflect because CCRB did their job and substantiated misconduct, while we have no idea if NYPD even did a thorough investigation, including on misconduct that's not in CCRB's jurisdiction. I hope NYPD finally serving the CCRB's charges means the NYPD and the police union won't try to play more tricks in the month ahead, and that Alonghi and Cianfrocco are fired as soon as possible. Without Win, this past year and a half, I have felt like part of myself is gone. Are you considering my time as
Yeah, the time did expire. What I would like though is for that testimony from her to be submitted, to be included in the record for sure, because it's very, very important. Thank you.
Thank you for allowing us to speak, Chair Salam and Councilmember Caban. Thank you for being here and speaking well about my brother. I have a lot to say. The time won't cover it, but I'll start. My name is Sami Feliz. I'm the brother of Alan Feliz, who was killed by NYPD Lieutenant Jonathan Rivera. I'm here to make sure that Commissioner Tisch has not tricked you into believing that she cares about accountability or New Yorkers' safety. She made it very clear she only cares about protecting herself and abusive officers when she refused to fire Lieutenant Rivera despite her own deputy commissioner's guilty verdict. Many of you know Alan's story. On October 17, 2019, then Sergeant Rivera and officers pulled Allen over for allegedly not wearing a seatbelt, which he was. Within minutes, they threatened, beat, tased, and Rivera shot him at point blank range in the chest. For almost 6 years, my family and I have rallied and protested instead of mourning. We thought our struggle was finally ending when Deputy Commissioner Rosemary Maldonado found Rivera guilty and recommended that he be fired this past February. Finally, we thought we can tell Allen's 6-year-old son that his father's killer will no longer have a badge and gun. Then, after dragging her feet for another 6 months, Commissioner Tisch overturned her own deputy commissioner's ruling, a decision that was first reported by the NYPD's and the New York Post, alongside quotes from 3 different police unions, all singing Tisch's praises. Tisch tossed Maldonado's credibility, finding without sitting through the trial by relying on a 5-year-old report from a different investigation with a different legal standard. At best, this is an arbitrary joke. At worst, it is catering to police unions for political gain. Tisch's decision makes it clear that the sole authority to discipline officers must be stripped from the police commissioner. We hope Tisch would listen to the cries of the community members, organizations, elected officials, especially after her promises to clean up the NYPD. Instead, she proved that she is no different than Mayor Adams and his other corrupt commissioners. The devastation my family has felt in this corrupted decision is hard to describe. My family has lost all trust in the NYPD. The thought of being pulled over terrifies us. This fear is not an overstatement. Since killing Allen, Rivera has continued to harm New Yorkers. In 2023, the CCRB substantiated yet another fireable charge against him. So the question remains, why is he still on the force? Thank you for allowing me to exceed my time as well.
Thank you as well. And I would definitely like to, if you have any more to submit, please do.
Thank you so much.
Thank you both. If there are no more questions from the other members, thank you.
Next panel, we'll hear from DeJuan Collins, Jackie Gostigan, Claire Thomas, and Genevieve Wong.
All right, you may begin in whichever order.
Is it on? Okay. My name is Jackie Gazdagian, and I'm the Senior Supervising Policy Counsel with Brooklyn Defender Services. I want to thank the Committee on Public Safety and Chair Salam for holding this critical hearing. The NYPD Commissioner can and regularly does reject or downgrade CCRB and internal NYPD recommendations for officer misconduct. In light of the demonstrated inefficacy of the current system at reining in police abuse, neglect, and biased policing, the City Council should explore utilizing every option at its disposal to allow for a more active role for the Council in the selection and approval of the NYPD Commissioner and removing the Police Commissioner's final authority over NYPD discipline. As the Council is aware, there has been a surge of NYPD in-custody deaths, and NYPD has not been held accountable for the lives lost. Part of this conversation includes accountability and oversight of NYPD's unlawful police-citizen encounters, use of broken windows policing, increasing policing of poverty, and unlawful use of custodial arrests. Because these tactics and policies increase the risk of custodial arrest, they also increase the risk of inability to access medical care in NYPD custody. NYPD is increasing its policing of poverty, and what's compounding this is that NYPD continues to routinely violate criminal procedure law when they're failing to issue appearance tickets in lieu of arresting individuals for low-level offenses. Custodial arrests for these low-level offenses are on the rise, and according to our arraignment supervisors, desk appearance tickets are down to about a third of what they used to be. One problem in particular is that NYPD has its own exceptions to issuing desk appearance tickets in the patrol guide. Specifically, these exceptions include something like not having a verifiable address. Many of these low-level cases are also not bail eligible, so that means that the person will be in the custody of NYPD and then released after arraignment. NYPD, however, claims that while they are in custody, they still need to be accompanied by an NYPD officer to receive medical treatment. I'll just sum up this paragraph, or go to the hospital. NYPD claims that they don't have enough officers to provide escorts, even if there is an ambulance on site, so people in custody are not receiving medical care. And now NYPD officers are asking attorneys to rush through their cases in arraignments because NYPD is going to wait on providing medical treatment until after the person is arraigned. So either DOC can take custody of the person or the judge will release them from NYPD custody. Also, officers can avoid having to escort someone to receive medical treatment and pass liability and responsibility for care onto someone else. We thank the council for the opportunity to testify and for addressing the lack of oversight and accountability of NYPD practices related to police-citizen encounters, custodial detention and arrest, and the crisis of deaths in NYPD custody. Thank you so much.
Thank you for your testimony.
Good afternoon. My name is Claire Thomas. I'm a public defender with Legal Aid Society Brooklyn Trial Office, and I represented Christopher Nieves, who was the most recent person to die in NYPD custody. Today, I will share my experience in arraignments on August 29th to highlight the impact that a culture of impunity and lack of accountability creates, a police department that refuses to recognize the dignity and humanity of the people that they have dragged into their custody. Deprivation of liberty should not result in deprivation of life. On August 29th, I arrived at criminal court arraignments and picked up the file for Mr. Nieves, who was being detained after being arrested for taking food from Whole Foods, a low-level offense. At around 5 p.m., I went to the holding area, which is controlled by NYPD, and it's behind the courtroom, to speak with Mr. Nieves. This area is grim, dirty, generally always crowded, has a lack of seating, which often forces people to have to sit on the floor for hours at a time. There were at least 3 NYPD officers there that night. When I met Mr. Nieves, I immediately realized that he wasn't well. His skin was a sickly yellow color. He was disoriented, and he told me he had just been in the hospital for a few months being treated for a staph infection. He then showed me his foot, which was all bandaged up, and he was very clearly in pain. There was a real possibility that bail would be set. Despite the charges being low level, the DA was requesting bail, which would force Mr. Nieves to go to Rikers. I wanted to ensure that Mr. Nieves would go to the hospital, not Rikers, so I told the arraignment ADA that he needed immediate medical assistance. The ADAs were both unperturbed and insisted that they would request bail anyway. While trying to negotiate a favorable outcome for Mr. Nieves, I continued to check on him and his condition. Each time, and with NYPD officers present in the holding area, I saw him lying on the ground on his side. A few people in the back told me that they were worried about him because he kept passing out. At around 6:45, just wrapping up, sorry, I advised Mr. Nieves to ask NYPD to be taken to the hospital. I checked in with NYPD as well shortly after, and they told me they were handling it. It wasn't until closer to midnight that I heard anything else. One of the NYPD officers came into the courtroom requesting Mr. Nieves' file. I asked her if Mr. Nieves hadn't in fact been brought to the hospital. She didn't say anything and just made this gesture towards me like she was cutting her throat. She then walked away from us without saying anything else. It was deeply disturbing, but I didn't assume the worst because I'd already been told he had been brought to the hospital hours ago. So I finished the shift, I went home, we never heard anything, and the next day I found out from Instagram that he had died in the courthouse that night. Mr. Nieves died alone in a cell after 10 p.m., hours after he and I both requested that he receive medical attention, but NYPD refused to give him the medical help that could have saved his life. I'm calling on the City Council to please hold NYPD responsible for Mr. Nieves' death. I'm demanding that not another life is lost by NYPD's failure to act and by the city's inability to hold officers accountable and responsible for misconduct, especially when either action or inaction results in death of one of our community members. Thank you.
I do have a question.
Yes.
And for those of you who have run out of time that had more testimony to speak on, definitely please submit that testimony to testimony@council.nyc.gov. My question is, and I don't know this. I'm a person who, of course, as you all may know, was arrested and sent to prison for a crime that I didn't commit, but I don't know the answer to this question. Do you know if there is an opportunity for individuals being held in police custody to eat? And I'm asking that because I know if you're on Rikers Island, yes, there's breakfast, lunch, and dinner served, and so forth and so on. But I'm just wondering, because it's occurring to me that when it's a low-level offense like someone stealing food, is there food at the precinct?
They have bags of peanut butter jelly sandwiches and water.
So there is.
That's it. And yeah, spoiled usually. That's
I've seen it to be like ham and cheese that isn't refrigerated. So I don't
So
think
non-refrigerated,
Yes.
spoiled milk, or wow.
The patrol guide does require that officers honor requests for food and water, especially within the NYPD holding cells even before they make it to central booking. But oftentimes our clients have reported to us the poor condition of the foods that they've had, sometimes completely inedible. They've often been served milk that has gone bad, food that has been left out, ham and cheese sandwiches that have gone bad, or not having their own dietary restrictions honored. And there have been multiple reports of that kind of treatment. Also multiple reports of when they request water, sometimes they get water in like the tiniest cup, or sometimes they only get it once. Oftentimes our clients are also quite afraid that they might have their DNA collected surreptitiously by the NYPD if they even accept water or some other beverage from the NYPD in the NYPD holding cells.
Not to mention that the holding cells are...
Your microphone.
Not to mention that the holding cells are very nasty. Bugs, rodents, feces in the toilet because it's clogged up. The water doesn't work in its holding cells, so it's very decrepit in there.
Wow, I thought conditions might have changed since 36 years ago I was introduced to the system. But thank you for your answer to my question.
I just wanted to add one more thing to that question and one more part of the answer to your question. Things should have changed because they have been sued previously for the conditions in pre-arraignment holdings. And there is a settlement in place where they were supposed to ensure some basic dignity in the pre-arraignment holding areas. But the consistency of their compliance with that settlement has been, I would say at best, poor.
Thank you. And if you have testimony, I know he said ladies first, so I'm just,
Yes, thank you.
Well, Chair, may I before?
Sorry, yes.
I just want to say, can you remind me your name, the attorney for Mr. Nieves?
It's Claire Thomas.
Yeah. What happened to Mr. Nieves is just disgustingly horrific. But I also want to point out that the effects of this go much further. I was in your position not that long ago, and I remember, I'm pretty sure it was in my first year of being a defender, I was working a night court arraignment shift, and there was a client in the back who, during the shift, attempted to hang himself. And everything had to stop, and all the court officers had to run into the back to take him down from the belt that he was hanging from. And it is just a horrifically traumatic experience for the people who work and advocate for these folks as well. So I am sorry that you experienced that you're continuing to have to process that and deal with that. I hope that you get any support that you need. Like vicarious trauma is very, very real. And I just want to make a finer point of establishing that, the deaths in and of themselves are horrific and must stop. But the pain and the trauma and the impact is felt by a wide set of folks, and it certainly affects the work that you're trying to do every day. So I'm sorry.
My name is Jen Vin Wong. I'm a supervising attorney with the COP Accountability Project within the Legal Aid Society. And as we've heard just now, as public defenders, we are witnesses to the impact that police misconduct can have on a person's liberty and ability to live with dignity. I want to point out for this council, first and foremost, that we are now over a decade since the decision in the stop and frisk litigation. NYPD is still under federal monitorship, not in compliance. And our public defenders across all 5 boroughs continue to hear about rampant harassment, and unconstitutional stops and frisks by NYPD officers every day. I will note that we have submitted written testimony that details our recommendations to strengthen accountability more broadly, as well as our 10-point plan that we released with our sister defender organizations this morning. But I would like to take the opportunity to highlight the growing crisis we face today, and that it is a part of a larger history of NYPD's culture of impunity. We've noted that 40 people have died in NYPD custody in 2023 and 2024, the highest two-year toll in nearly a decade. And this year alone, at least 9 people have tragically lost their lives, including legal aid clients while in the custody of NYPD. And despite those deaths, NYPD still has yet to provide any comprehensive information about it or the steps that they're taking to prevent similar tragedies. Now, I want to note that in stark contrast after the repeal of 50A, the CCRB made a wealth of information available to the public in order for the public to meaningfully and analyze how misconduct was being treated in this city. In stark contrast, NYPD has not done so. And in fact, to this day, they still have not done so. They have released select information that they have deemed important to the public, but they have not released information that we need to assess their effective, whether or not the disciplinary system is effective or not. We've heard a lot about the Force Investigation Divisions, and I want to highlight that we don't know anything about the Force Investigation Division investigations generally because we don't have that information. It's not posted publicly. What we do know is public reporting, and from many of the families of these high-profile deaths, we have learned that FID investigations have been deficient, to put it shortly. FID was created 10 years ago to restore public trust, but it has failed to do so. And I want to note that the FID was actually created as a response to the death of Eric Garner. And now, after all of these additional deaths over the past 10 years, so many high-profile deaths, FID investigations are still deficient. And so that is why the Legal Aid Society is calling for an independent agency to be the primary investigator in these instances because NYPD cannot be trusted to police itself. One last thing I wanted to note, and it is in our written testimony, so I'll wrap up very shortly. From 2021 until today, there have been 46 substantiated cases for failure to render medical aid. The most common penalty for that was less than 5 days. That's it. Failure to render medical aid should be serious misconduct and it should be treated as such. Less than 5 penalty days shows a disregard for the fact that people who are in NYPD custody, who are entirely reliant on NYPD to render medical aid and to make sure they get medical assistance, they're not doing it. NYPD is not taking this seriously. Thank you for the time today. I wanted to just say that the current administration's revival of broken windows policing is what coincides with all of these increases of misconduct complaints and of these high-profile deaths.
Thank you for your testimony. You may begin.
First of all, I want to say thank you, Councilmember Salam, and members of the Public Safety Committee for allowing me to be here to testify today. My name is Dewan Collins, and I'm a Civil Rights Union leader with Vocal New York. Misconduct in the NYPD is out of control. It's unchecked and a massive abuse of power, from fabricating felony complaints to body cam footage and manufacturing evidence. Anything else they need to justify an arrest to shape their narrative to bring it to their final conclusion. I have experienced NYPD misconduct firsthand for the 34th Precinct in my own case. A now retired sergeant of the NYPD, Lorraine Ramos, falsely accused me of strangling my ex-girlfriend in 2018 to the point of unconsciousness. That never happened. Ramos has a history of fabricating felony complaints, from civil cases for Malik Stewart versus the NYPD, 19 CV 05499, and Collins versus the NYPD, 19 CV 7156, and internal NYPD records. Yet despite this, Ramos' treachery was covered up in a lawsuit in the Stewart case where the city of New York settled. Ramos was promoted to sergeant soon after my arrest and allowed to retire with his sergeant's pension at the taxpayer's expense. Is it just for the NYPD officers that allegedly fabricated felony complaints to be promoted to sergeant and allowed to retire with their pension at the taxpayer's expense? Is it just for the Manhattan District Attorney to prosecute a fabricated felony complaint by the NYPD? Is it just for the New Yorkers to pay millions of dollars in settlement suits due to intentional misconduct by the NYPD? According to a 2025 analysis data released by the Legal Aid Society, from 2018 to 2024, it cost New Yorkers approximately $750 million in alleged misconduct lawsuits. Misconduct in the NYPD works hand in hand with misconduct in the DA's office. Once police fabricate their records, the very public servants that are supposed to intervene to prevent a constitutional violation go along with the status quo of doing business as usual because of a benefit promise or received or fear of reprisal or loss of a benefit. As a result of the misconduct, a cover-up ensues by other agencies. A wrongful conviction is born and black or brown families are destroyed, like mine's. This misconduct happens constantly because there aren't any real oversight committee with final and binding authority over the Commissioner of New York, over the Commissioner of the NYPD. No checks and balances for police officers. They have qualified immunity, complete cooperation from other city agencies. The idea of even giving the average citizen qualified immunity, protecting them from accountability due to the levels of crimes perpetrated upon innocent New Yorkers for their constitutional rights being violated, will receive disdain, scoffing, and ridicule. Would it not? There's no respect for the rule of law in New York when it comes to the NYPD. They feel they're above the law because when it comes to the police, they feel they're above the law because no one would hold the police accountable. And there's definitely no equal protection of the law. To allow NYPD unfettered power over the citizens of New York is to abolish the rights of New Yorkers. Let's face it, absolute power corrupts absolutely. Even when cops are held accountable, which is rare, their discipline is only a slap on the wrist. If a doctor commits medical negligence, they lose their license.
I do have a question, being that the time has expired. Are there any recommendations that you offer as a representative of the people that you are representing as well?
Oh, yes, we have a recommendation to support our bill to end qualified immunity. That is one. Another recommendation
And
is...
do you have that bill number just so that it's part of the testimony?
I can get
If not, you can get it to us.
Yeah,
and
I
I'll
can get it
on.
for you. So that's one of the recommendations. Another recommendation is to strip the commissioner of their final making decision authority when it comes to police misconduct. So if I can continue.
Well, actually, because the time did expire, I just kind of wanted you to wrap if you could, because we do have the standard of 2 minutes.
Okay, gotcha.
And we do also offer the testimony to definitely be included in the transcript. So it's not like it wouldn't be, but that's why I wanted to maybe ask that question. And if there is a way to summarize as you end, that'd be perfect.
All
And
right,
then
well,
also submit your testimony.
Okay. So I just want to say in closing this, I want to leave with this famous dissenting opinion from Justice Louis Brandeis in the Olmsted decision of 1928. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy. Olmsted versus United States, 277 U.S. 438 at 485. Thank you for your time.
Well, thank you. I appreciate that. If there are no questions, thank you for your testimony.
Thank you.
Next panel, we'll hear from Alyssa Johnson, Brian Entropes, Barbara Manu, and Yvonne Jennings. After this panel, we'll be moving to Zoom testimony.
Good afternoon, and thank you for organizing this important hearing. My name is Alyssa Johnson, and I'm a legal fellow with the Surveillance Technology Oversight Project. The Surveillance Technology Oversight Project is a civil rights and anti-surveillance group that advocates and litigates against discriminatory surveillance. Lack of meaningful oversight for NYPD misconduct harms all of us and costs lives. It also hamstrings attempts to hold police accountable for misuse of surveillance technologies, such as pervasive over-policing of communities of color using technologies like ShotSpotter, identification and tracking of protesters using drones, circumventions of prohibitions on facial recognition technology by outsourcing requests to other departments like FDNY, and continued noncompliance with the post-tax reporting requirements. Under existing toothless disciplinary procedures, NYPD officers feel empowered to violate our civil liberties, secure in the knowledge that it will likely cost them, at worst, a handful of vacation days. STOP joins other advocates testifying today in asking the City Council to implement major reforms to disciplinary processes. Among them, we ask that NYPD be required to promptly charge officers upon confirmation of charges by the CCRB to avoid delays and hitting the statute of limitations. We also ask that the City Council reissue a resolution similar to Resolution 1538, urging that the legislature pass a bill giving final adjudicatory authority over discipline to the CCRB rather than the police commissioner. We also recommend, as CCRB requested today, that they be granted direct access to NYPD camera footage and other evidence. Fourth, we also recommend that the council continue to allocate increased funds for staffing at CCRB. And finally, we'd ask that the city take steps to end police officers' qualified immunity in civil suits. Thank you for the opportunity to testify today.
Thank you as well. Yes, sir.
Good afternoon. My name is Brian Aaron Price, and I'm an attorney with New York County Defender Services. I'm here to talk to you all today because two men that I knew and represented can't speak for themselves. Those men were named Musa Satin and Diallo Ibrahim. Both of these men died in the custody of the NYPD this year. One of them died in an arraignment holding cell several blocks that way, 100 Center Street, and the other died in an NYPD holding cell in a Midtown precinct. The deaths of both of these men are directly attributable to a culture of apathy and neglect and impunity in the NYPD. This is a culture that the CCRB can do something about. And I'm here to tell you all that we are at a crisis point in terms of these in-custody deaths. And those of us who are attorneys on the front lines of this system have known that for some time now. Any public defender in any borough of this city will tell you that they've arraigned too many clients who are sick, who are experiencing dangerous medical symptoms, who are in a mental health crisis, or are dealing with untreated injuries from an arrest by the NYPD. This overwhelmingly sick group of individuals is then forced to sit in a squalid cage in the custody of the NYPD, oftentimes upwards of 24 hours before they even see a judge. There are no medical personnel on site to attend to our clients' medical needs during this time. There are no doctors on site making sure our clients don't die. And the NYPD doesn't care to do this, nor are they qualified to do so. I have personally arraigned clients with bloody faces with open wounds. I've arraigned clients too weak to even stand up in front of the judge. And there are few public defenders in the city without a story of this kind. Our clients are uniquely vulnerable in terms of their health. And such a blatant disregard of their needs by the NYPD, it's no wonder people are dying at an alarming rate. Why would the NYPD have any incentive to change this, to investigate this, when they themselves are the ones doing the investigation? As you know, it's the Forced Investigation Division that does this. They're accountable only to themselves, and we don't see that information. This is not an acceptable situation, and the City Council does not have to accept it. The City Council must require the CCRB to investigate automatically these in-custody deaths whenever they occur. That is one of the only ways we're going to get to the truth of these incidents and prevent them from occurring again, and to break this cycle of neglect and apathy that is increasingly transforming an arrest in New York City into a death sentence. Thank you.
And thank you as well. You may begin. Yeah, just press the button to the, yes.
Hi, and good afternoon. Sorry about that mix-up. My name is Lauren Carbajal, and I'm speaking on behalf of the Legal Defense Fund. I'm an assistant counsel there. We thank the committee for the opportunity to provide testimony today. Today, we're calling on the City Council to empower the CCRB, particularly its Racial Profiling and Bias-Based Policing Unit, to carry out its important mission of investigating and issuing findings related to biased policing. First, the CCRB must be fully staffed and funded. CCRB suffers from a lack of resources to effectively hold the NYPD accountable, and they face an increasing amount of complaints each year, yet their budget and headcount have not correspondingly increased. This makes it impossible to keep up with a growing caseload, which could allow misconduct to go unaddressed. We appreciate the City Council's recognition of the importance of a fully funded CCRB and racial profiling unit, as evidenced by its 2024 request to increase CCRB's baseline by $15 million. We urge you to stand strong in such requests. The racial profiling unit also needs direct, unfettered access to NYPD databases and records. Currently, the CCRB must formally request that data, such as body camera footage, complaint histories, performance evaluations, and data sets on past conduct from the NYPD itself. And they are only entitled to access such data within 1 year preceding the events alleged in a complaint. This is insufficient for the RPBP unit to conduct a meaningful analysis. When access to information is blocked or constrained to such a short time frame, these investigations are severely hindered. The RPBP unit can be a powerful tool to ensure that officers engaging in racial profiling and discriminatory, unconstitutional conduct are held accountable. The City Council must ensure that it can fulfill its mandate. Finally, for decades, the NYPD has ignored or undermined CCRB recommendations, which disproportionately harms Black communities. The NYPD substantiates only about 10% of CCRB recommendations, leaving the vast majority of misconduct unaddressed, especially racial profiling complaints. I'm almost finished. The NYPD's refusal to discipline officers, even when the CCRB substantiates misconduct, is not only an abstract failure, it is a devastating trauma for families. Too many Black New Yorkers have buried loved ones while watching the officers responsible remain in uniform. The family of Alan Felice was very recently confronted by the NYPD's decision not to impose discipline, even where the CCRB substantiated claims of officer misconduct. As the primary oversight body of the NYPD, the City Council must ensure that these instances of violence and miscarriages of justice stop. Thank you so much for your time.
Thank you as well. You may begin.
Hello, sir. I've spoke here at least 3 times, public safety. And Jonathan Darsh I met with years ago. The stalking of me by this cult started May 11, 2006, drug-related. I don't do drugs. It turns out I had a client, which clients I had, who had a part of a cartel. I don't do drugs. I reached out to all of y'all for help, got nothing. I came to your wonderful office, Sir Yusa, last year and showed some letters that have gone to the White House. They're 5,000 plus. I just showed them to Ms. Cavan, and I said to her, the letters are nothing. And the emails now on overtime to Wallace and Levitt, Pam Bondi, Kaz is his name, Matt Frazier, what's her name, Varlak, the chief of staff to the mayor, all get the same email. They'll be on overtime to everyone, and they're resent. I'm being electrocuted by the man over me. I went to the 47th precinct on this 16th Tuesday. They were horrendous to me. And I am where I am now, unless you piss me off. I get really not nice. The next day I had to go to the hospital to have a cardio, and I almost fainted by the elevator. I went to NAN on Saturday, National Action Network. There's a young man that was back there, and I reached out to some people there. But the piece de resistance is on the 1st of August, I almost had my 3rd heart attack. My 2nd heart attack was caused by the man upstairs, along with almost a 3rd. And that one, my pressure was 156 in the ambulance. In the hospital, it went to 216 over 109 at 3:27 a.m., of which they marched around in there. It was a Tuesday. It wasn't busy. No one was in there. And they left me to die. So what I just said to you, I'm not saying a tenth of any of this. I fear for my life and safety. And I had reached out to you, tried to speak to you privately for like 10 minutes to show you some letters that were given to your Herrera? Yes, last year, right after my heart attack. Very important, the letters that went to Biden. Yes, I ask again, could you spare 10 minutes of your time sometime that we could talk? Very urgent. Thank you. Because I really don't know what to do. Because I reached the CCRB, that's Jonathan Darsh. And I reached out to him the start of 2006. I reached out to him probably, how old is his child? When his child was 3 or 4. But they don't handle stalking. No one does. But I'm just sitting watching. When I leave here, I'm harassed horrendously. And I'm always at the camera. So we got a problem. I don't understand. So if you could help me out, I greatly appreciate it. Okay? Thank you.
Thank you for your testimonies as well.
Yes, thank you.
We're going to now open for virtual panelists. We will be calling individuals one by one to testify. Once your name is called, a member of our staff will unmute you, and the Sergeant at Arms will set the timer and give you the go-ahead to begin. Please wait for the Sergeant at Arms to announce that you may begin before delivering your testimony. Thank you.
Thank you. We're going to start with Michael Sositsky, then we'll move to Tanisha Grant, and then Christopher Leon Johnson. We'll start with Michael.
You may begin. Michael, if you can hear us, please unmute and you may begin your testimony.
I think he was unable to unmute.
We're going to move to Tanisha Grant.
There we go. It just allowed me to
Oh.
unmute.
Oh, perfect.
Thanks so much. So good afternoon. I'm Michael Sositsky, Assistant Policy Director with the New York Civil Liberties Union. So we really can't separate the increase in complaint activity that we've seen in recent years from this administration's really aggressive approach to policing. Stop and frisk activity has surged to levels that we've not seen since 2014. With staggering racial disparities. Low-level summonses and arrests have increased, vehicle stops have increased, the NYPD keeps creating specialized unit after specialized unit, neighborhood safety teams, public safety teams, community response teams, quality of life teams, euphemisms to obscure the reality of what they're doing, which is a full-throated embrace of broken windows policing, driving an unacceptably high number of unconstitutional and racially biased stops with little supervisory review, and no consequences or any kind of discipline, meaningful discipline, when these officers are violating New Yorkers' constitutional rights. And alongside all of this, we've seen a systematic effort by this administration to weaken external oversight. While some of the more egregious attacks on this oversight have been addressed, under this administration, we saw the CCRB forced to suspend entire categories of investigations due to budget cuts. We saw the NYPD invent deadlines out of thin air to justify their short statute of limitations policy. We've seen and still see a severe reduction in staffing for the Office of the Inspector General for the NYPD, having gone from 37 staff members at their peak in 2017 to just 3 filled positions as of last month. 3 people for an office meant to oversee the policies and practices of a department that employs around 34,000 uniformed officers and thousands more civilian employees. Whatever the NYPD professed here today about its commitment to discipline and accountability, we know that we will not find accountability from within the NYPD itself. There's hundreds of pages in the Federal Monitor's report on NYPD discipline that paint a full picture of a discipline system that is simply uninterested in disciplining officers. The CCRB and the Office of the Inspector General are by no means perfect entities,
Your
but they
time's
provide
expired.
something
Thank
that
you
the
for your
public
testimony.
desperately needs, which is independent investigations into the NYPD. Those agencies need to be resourced. They need to have the tools that they need to have the direct access to the information that they need to complete their investigations and fulfill their mandate. And the council must also be doing more to be reining in the abusive tactics being employed by officers themselves that are driving misconduct. We need that accountability on the back end, but we also need to be doing more to cut off the harms, the harassment, the racial profiling, and the excessive force that officers are using in communities in the first place. Thank you.
Thank you. Next, we'll go to Tanisha Grant.
You may begin.
Hello. Give me a second. Hello, Chair Salam and fellow Public Safety Committee City Council members. My name is Tanisha Grant, and I am the founder and executive director of Parent Support and Parents New York. We are one of the organizations supporting the family of Sanaya Cheatham, who died in police custody at the very tender age of 18. Supporting the family of Sanaya has been very difficult. Ms. Thomasina Cheatham has lost her only daughter. Sanaya's brothers have lost their only sister. After having a great day, Sanaya somehow ended up dead in the 41st precinct in the early hours of July 5th. Her family are still waiting for answers. Death in police custody is more than traumatic. It is often avoidable, and it more often than not goes unpunished. It is the NYPD's job to keep folks safe while they are in custody. This young Black girl has been given very little attention and compassion by this administration. Ms. Thomasina remains in limbo, trying to figure out why her 18-year-old Black daughter is dead. The police are not above the law. Our billionaire commissioner, hired by a corrupt mayor, is not above the law. Action speaks louder than words, and the actions of the police and the so-called oversight are non-existent. CCRB findings are often overturned, like in my good friend Delron Small case, when the officer who killed him on video is still a police officer. Delron was a childhood friend I met while we both were in foster care as children. We are still grieving that loss and the lack of accountability. Wayne Isaacs should not have a job. There will never be trust between our communities and NYPD as long as they continue to be above the law and go unpunished when our families are somehow unalived in police custody. Ms. Thomasina Cheatham and her family deserve answers. The 41st precinct in the Bronx should be held accountable for the death of Sanaya. At the end of the day, they are negligent, and they should be criminally charges against the police station and everyone who was on duty. I'm almost finished. The CCRB should have more power to punish these officers who are killing our loved ones. As Black parents, we are so afraid every time our children leave the house because we know they aren't safe. One of the reasons they aren't safe is because the NYPD does whatever it wants. The ability the NYPD has to investigate itself only works for them. We must end qualified immunity. Chair Salam, please fight for our communities. Please fight for Sanaya Cheatham. Her family really needs transparency and answers on what happened to Sanaya. Thank you for listening to my testimony.
Thank you.
Next we'll go to Sama Sise.
You may begin.
Thank you. Good afternoon, Chair Salam and members of the City Council. My name is Sama Sise. I'm an attorney at the Center for Constitutional Rights. And I'm going to just really build on what a lot of the other attorneys and Michael from NYCLU talked about, which is the NYPD's refusal to adequately discipline officers who engage in unconstitutional stop and frisk practices. So the Center for Constitutional Rights, along with Beldock, Levine, and Hoffman, have been, for unfortunately over a decade, lead plaintiffs' counsel in the Floyd versus City of New York litigation that led to the current federal monitorship of the NYPD's stop, question, and frisk practices. Something that's often not discussed about the court's order in Floyd is that the decision really pointed to the fact that discipline was important and remains important to stopping unlawful SQF practices in New York City. One of the orders that the court made of the NYPD was to give more deference to the investigations being conducted by the CCRB, because the CCRB is independent, right? It's an independent city agency that's staffed with experienced lawyers and investigators who are able to do the work that they've been tasked to do. The CCRB has jurisdiction to investigate improper stop, question, and frisk allegations under the abuse of authority category. But over 11 years later, after this court order, the NYPD has failed to comply. NYPD officers are rarely disciplined for unconstitutional stop and frisk, even when substantiated by the CCRB. And Chair Salam mentioned the Yates report, which is a recent discipline report that was submitted to the judge in the Floyd monitorship. And in the report, they show that the CCRB findings are not given deference as required by the court order. Oftentimes they're ignored. NYPD police commissioners have consistently exercised their unfettered authority over discipline to excuse officers of SQF misconduct by stating that they're just acting in good faith. And even when the misconduct
Thank you for your testimony. Your time's expired.
Thank you. What I will add at the end is that my testimony has been submitted on the record, but also the plaintiff's counsel and the Floyd federal monitorship. We put together a list of various recommendations regarding the NYPD discipline system as it relates to stop, question, and frisk, and that was included and submitted as well. And we would really appreciate the City Council to review some of the recommendations in that document. Thank you.
Thank you.
Next, we'll go to Christopher Leon Johnson.
Yeah. Hello, my name is Christopher Leon Johnson, and I want to make this clear. I know that very soon that I won't be able to say the stuff I want to really say, but while I'm at it, I'm able to say it. But I think that this hearing today was nothing but a sham because the CCRB, let's make that clear, that the CCRB works with the NYPD. Why won't the committee start calling out the CCRB themselves to really work with NYPD to where that the reason that these cops in these committees, these NYPD cops can do what they want because the CCRB are complicit with what they do. We go to these hearings at CCRB, make our complaints, and nothing ever happens because you start finding out that these guys and gals work together, and some of these guys are affiliated with the same cliques and cliques like Freemasonry and Rotary clubs and Lions clubs and all these type of clubs and these other cliques, and they work together. And I'm calling the city council to make it where that the police commissioner should not appoint any member of the CCRB because that's like a big conflict of interest. Why you have a committee where you have Joe Fox on the committee and everybody know that guy has a history, and it's like, yeah, he's gonna protect the cops. He's gonna protect the cops that works that he's boys and gals with. And it's like I said, people gotta start really looking to these cliques, to these these fraternal organizations that work hand in hand with the police unions. And people gotta start calling these ethical like the New York Dominican organization and New York Hispanic and the Guardians and all these organizations that work hand in hand with the police, working hand in hand with the unions, and that go work hand in hand with the CCRB. And like I said, people, like I said before, no, this is about to happen soon because the Raw Rivera rule that I'm gonna say this right now before I end here. Like I said, people got to start calling out the Freemasons in the city council because when you start calling out the Freemasons in the city council, this really picks up all the stuff that happens. All that happens within police corruption and how the city council is complicit.
Thank you for your testimony.
With
Your
the
time's
police
expired.
corruption. Thank you. Thank you so much. Thank you.
Thank you. If there are anyone that has not been recognized that wishes to be recognized, you may use the raise hand feature virtually. And if there's no one that has raised their hand, that concludes today's business. Thank you for your testimony.
Good afternoon and welcome to today's New York City Council hearing for the Committee on Veterans. At this time, I would like to remind everyone to silence all electronic devices. Also, going forward, no one is to approach the dais. I repeat, no one is to approach the dais. If you want to sign up for in-person testimony or have any questions during the hearing, please see the Sergeant at Arms by the desk in the back of the room. Chair Holden, we are ready to begin.
Thank you. Good afternoon. I'm Councilmember Robert Holden, Chair of the Committee on Veterans. Welcome to our oversight hearing on implementing recommendations from the Veterans Advisory Board. In 2015, the New York City Council passed Local Law 113, which required the creation of a Veterans Advisory Board, VAB. That's what we're going to call them. VAB was subsequently established pursuant to Chapter 75, Section 3103 of the City Charter. The VAB's role is to advise the Commissioner of the New York City Department of Veterans Services on issues concerning veterans as well as active duty, reserve, and guard service members, and to connect the Mayor's administration, DVS, the Council, and the veterans community. The 13 members of the VAB are appointed to a 3-year term, 7 by the Mayor, and 6 are appointed by the Speaker. Annually, 5 public sessions, 1 in each borough, are required to be held in order to collect public input on issues of importance and/or concern to the veterans community. In its annual report, the VAB recounts its activities for the past year and plans for the coming year, reports on progress of its prior recommendations, and offers new recommendations to the Mayor and the City Council, as well as to DVS. Today, we're going to be looking at the VAB's most recent recommendations in its 2024 annual report, which we received in early June, and we will be hearing from DVS and VAB about these recommendations. I want to note that this is a follow-up hearing to one which we held last January in response to the requests of interested public stakeholders about the structure and operations of the VAB. The VAB's 2024 annual report provides a range of recommendations. They cover the processing of grants of the PFC Joseph P. Dwyer Veterans Support Program, the appointment and requirements of VAB members, the encouragement and support of veterans for engaging in the local political process, increased funding for DVS, services for student veterans at CUNY, the policies and operations of veteran treatment courts, updating the VAB's bylaws, providing administrative support for the VAB, metrics for tracking VA claims and their resolutions, and DVS's contracting procedures, and more. So it's a laundry list of recommendations we're going to be going through today. Hearing the Commissioner's responses to each of the recommendations at this hearing. At this time, I would like to acknowledge my colleagues who are here, Councilmember Christy Marmorato and Councilmember Joanne Ariola. That's it, right? Okay. And on remote is Councilmember Vicky Palladino, I understand, okay? And I'd also like to thank the committee staff who worked to prepare this hearing, Alejandro Calval, our legislative counsel, Regina Paul, our senior policy analyst, Farah Rahman, our financial analyst, and finally, thanks to my chief of staff, Daniel Kozina. So I'd like to turn it over now to our legislative counsel to administer the oath to witnesses from the administration. So we have Commissioner James Hendon and Nicole Orlando from DVS.
Good afternoon. Please raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this committee and to respond honestly to council members' questions?
I do.
I do.
Thank you. As a reminder to all of our witnesses, please state your name prior to your testimony for the record.
Good afternoon, Chair Holden, members of the Veterans Committee, members of the City Council, and members of New York City's veteran community who are joining us today. My name is James Hendon, and I have the privilege of serving as Commissioner of the New York City Department of Veterans Services. I am joined by Nicole Orlando, our agency's Deputy Chief of Staff. Thank you for convening this hearing on implementing recommendations from the Veteran Advisory Board. At its core, today's discussion is about translating the lived experience of New Yorkers who served into policy that works at street level, policy we can fund, measure, and sustain. As defined in the New York City Charter, Chapter 75, Section 3103, the Veterans Advisory Board consists of 13 veteran community members, 7 of whom are appointed by the mayor, 6 by the Speaker of the City Council. They represent every borough and reflect the diversity of service in our city. Their charge is simple and essential. Keep the lines of communication open, identify what is working, and name what must change. In 2024, the board held 5 public meetings, 1 in each borough. This year, they've held 4 meetings thus far. I invite everyone to participate in the board's final session of the year to be held on Wednesday, October 29th at 6 p.m. in Brooklyn, either in person or online. Details about the meeting as it approaches can be found online at nyc.gov/vetboard. Before responding to the board's recommendations, we would like to first offer sustains and improves on the execution of the Veterans Advisory Board itself, including DVS's role in VAB activities. Sustains. First, we appreciate that the board now focuses each of its meetings on 1 to 2 of DVS's charter mandated areas. Our charter mandated areas are healthcare, housing, benefits, culture, education, and employment. Culture, which consists of veteran community recognitions, activities, and events, undergirds all meetings. It is mentioned in the background regularly. That said, the 5 annual meetings perform a deep dive into healthcare, housing, benefits, education, and employment. We are grateful to the VAB for this innovation. The evolution of having the NYC Veterans Advisory Board dually serve as the Community Veterans Engagement Board for the City of New York was a watershed, for reasons to be discussed later in this testimony. Another sustain, public meetings are handled in a way that is efficient and professional while affording attendees the opportunity to present their viewpoints and feel seen, respected, and heard. Another sustain, the VAB's advocacy has increased the mediums through which meeting notifications are posted. Notifications that years ago were only made via email to the veteran community and to veteran community leaders are now made via email, social media, newsletter, digital flyers distributed by DVS and the board, and they are posted on the DVS website, among other places. Final sustain, the board is nearing 100% strength. Currently, a prospective mayoral appointee is undergoing vetting to fill a recently vacated seat. Once filled, the board will be at 100% strength for the first time in more than 5 years. This is a testament to the appointments unit from the mayor and speaker's offices. It is important to give credit where credit is due. Now to improves. First improve, we believe the way that the VAB lays out its recommendations should evolve. Recommendations should be displayed in a manner where it is easy for the policymakers who read it to view exactly which recommendations are addressed to them. Suggestions should be broken out as city, state, federal, then broken down further within those tranches as executive, legislative, and judicial. Doing this will attract more policymakers to read and act on the document. We, DVS, next improve, we, DVS, commit to increase the entities that we spread the word to when promoting Veterans Advisory Board meetings. We will inform not just veteran service organizations, as we currently do, but all community benefits organizations, all New York City elected officials, all community boards, and all community education councils. Next improve, we need to establish mechanisms for codifying DVS VAB agreements and Veterans Advisory Board bylaws such that they carry over as city council administrations change, mayoral administrations change, and or the Veterans Advisory Board membership changes. Day-to-day operating norms must be instituted in a manner where the norm is enforced and respected without needing to be codified into law. The next improve, moving forward, DVS commits to publishing a response to the Veterans Advisory Board report within 90 days after the report is published. The VAB report, which is traditionally published in the spring, is a point-in-time snapshot of issues raised during the calendar year before. As a way of closing the loop, our response will provide an update on where things stand and clarify any topics that need to be clarified, such that these items too are part of the public record. It must be said, DVS will not publish a rebuttal to the VAB report. We will publish what is effectively an update and a response. In addition to largely appearing in this testimony, our response to the board's 2024 report will be posted online no later than 90 days from today. Next, improve. A meta issue that transcends the VAB but affects the VAB is a need for increased attendance. Roughly 20 to 30 veteran community members attend each of the board's public meetings, all of which are hybrid at this time. Among other things, increased attendance directly ties to challenges with veteran self-identification. In a city where, according to FY23 VA data, only 24.1% of veterans self-identify, increasing New York City's self-identification rate could have the effect of tripling attendance at VAB meetings. Increased attendance equates to broader diversity of ideas, enhanced influence in multiple spaces, and greater synergy amongst meeting attendees. In general, VAB attendance, which like all veteran gatherings, is largely influenced by self-identification, is the key to the veteran community having a stronger voice. And now to DVS's responses to the 2024 Veterans Advisory Board report. So each year, the Veterans Advisory Board distills community input into recommendations for the mayor and city council, recommendations for DVS, and recommendations for legislation and programs. What follows is our response, where we agree, where we have acted, and where we commit to continued work to the board's recommendations from their latest 2024 report. For the record, the 2024 Veterans Advisory Report and all VAB reports dating back to 2002 can be found online at nyc.gov/vetboard. So first, recommendations to the mayor and city council. First recommendation was processing of the private first-class Joseph P. Dwyer Veteran Support Program grants. The board rightly noted delays in 2024 related to approval and reimbursement for the Dwyer program. The cause was a process error that routed funding from the New York City Department of Health and Mental Hygiene rather than to the Department of Veteran Services. In response to FY25 process delays, FY26 Dwyer funding and Dwyer monies moving forward are recognized by the Mayor's Office of Management and Budget as belonging to DVS at the start of each fiscal year. For future years, we're working with state partners to establish a direct state to DVS flow of funding. The objective is straightforward: reliable, timely support for peer-led mental health programming without administrative drag. An update, during this fiscal year, FY26, 31 New York City Dwyer projects are in operation. Details can be found at nyc.gov/vetdwyer. Next recommendation was appointment terms to the Veterans Advisory Board. The board recommends that every new appointment carry a full 3-year term, including appointments to fill a vacancy. We support this change. We also support a review to ensure balanced representation across all boroughs and stand ready to assist the mayor and the council. Next is attendance at public sessions. To strengthen accountability and continuity, the board recommends members attend at least 3 out of 5 public sessions each year, with mandatory in-person attendance in the borough they represent. DVS agrees this is a practical standard that will improve consistency, participation, and trust. We must say, correcting this issue hails back to the broader governance challenge mentioned in the improved section of this